Yes.
I beg to mention item number 24 to 26. The matter relating to all scheme of Sabka Vishwas.
24 to 26, yes.
Notify required 2 weeks time to file affidavit. Affidavit will be required in this case. So the scheme has already been lapsed.
Who is for the petitioner?
I have taken consent from.
Okay,
this
Mr. SCKL, standing counsel for the
GST law.
GST. Submits a praise for
2 weeks.
2 weeks time to file affidavit. And submits that he has taken the consent of the other side. Full stop. He further submits that the scheme, the subsidy scheme.
It's Sabka Vishwas scheme.
Huh?
Sabka Vishwas legacy.
Anyway, the subsidy scheme has now has lapsed as of date. This is a matter after 2 weeks.
Much.
May please your lordship, my lord, I am paying for listing of this matter. Matter released to my lord, land compensation, my lord, not listing, not listed for a long time, my lord.
Bench 5, will bench 4.
May I please, your lordship? My lord, may I pray for listing a case on Monday next, my lord? It will be disposed of on that day because of, we will file an appeal. Appeal has not been disposed of. With that direction, it may
Can be taken up tomorrow also. What is it?
tomorrow,
Tomorrow, day after, anytime.
day after tomorrow,
Day after.
much.
Yeah, please, your lordship. We have consent of other side lordship, item number 19 and 10, 20 lordship.
Item 19 and 20, yes.
That matter may be taken up in the lordship after 2 weeks lordship.
Why?
The engaged counsel, Mr. N. Gogoi for respondent.
Mr. Counsel, this matter is of 2018.
Lord, but
Then?
engaged counsel, Mr. N. G. Gogoi, lordship, he is ill. Lordship.
He
Huh?
yesterday told me he is not well, man.
NG Gogoi.
NG, Naranjoti Gogoi.
NG?
Gogoi.
NJ Gogoi.
Suffering from pharyngitis. Yesterday he
DPNG
told
is also board.
2018 matter, Mr. Counsel, allotment of rooms.
2 weeks, 1 week, sir.
Is the room allotted to you? No.
no money.
1 week.
No. Why should we adjourn?
Because on the grounds of lordship, his illness lordship of engaged counsel. Because his presence is
Is
necessary.
it 2018 matter? What
He
is
yesterday
that?
told me that I am not going.
Okay, right. A genuine prayer has been made on behalf of Mr. NJ Gogoi, and counsel for the respondent number 3. Okay. This matter has been pending since to the year 2018. And as such, no further adjournment shall be given on the next day. List the matter when?
After 2 weeks, lordship.
First week of December, man.
Give it.
Lordship. 8th of December, lordship.
Well,
Alright.
19 interim order, man. That may be.
What?
Item number 19 interim order, that may be completed.
Interim order?
Yes, man. Item number 19.
Okay, interim order to continue till the next day.
What's the next?
Wait, please,
Give a date, huh? Fix, no adjournment.
Meet with the lordship. Item number 17 come after a week, my lord. Because I need some instruction, he is out of station.
Right. Mrs. N. Sakia, learned counsel for the petitioner, praised that. This is also reject 2017 matter.
After a week, because he has gone abroad and.
Who has gone
somebody
abroad?
said, my lord, a petitioner.
How is that relevant? He's not
No,
going
my
to
lord,
appear.
He might have received another case, he has received the amount, similar case, he has received the amount.
Okay.
So if the amount is received. there
Where's
is
the
no-
question of receive? It's been rejected. His prayer has been
Then it's-
rejected.
Last occasion, my lord, another case I have done, we are arguing here, then we call him, he already received the amount, my lord, 1 year back, he did not inform me. Now he has also, I have to confirm it, otherwise no question of.
Mrs. N. Sakia, learned counsel for the petitioner, praised that the matter may be adjourned for a week. On the ground that. It's so, on the ground that in a similar matter, the transport subsidy claim, the transport subsidy has been given. Full stop. The present case relates to rejection of a transport subsidy claim.
On the
And the
ground
case
of
has been
case
pending
pending.
since the year
The ground of case
2017. List the matter on. Give a date.
After. That's all.
No, 27 we fixed the matter. List the matter on 28.
All right. Yes,
May I pray for listing of a
Okay,
matter,
please,
my lord,
fine.
to
Huh?
2019 matter, my lord. For
2000,
admission.
2019 matter, my lord, for admission. Matter relates to release of security deposits fund. So, my lord, convenient date of the honorable court. may be-
When?
Any day.
Give it
convenient. 28/20.
On the prayer of
Right.
the petitions council, this is the matter on 20. Oh, mention memo, okay, 20th.
May I tell yourself, I beg to mention for listing motion matter, my lord. A similar case is to more of case, my lord. And my matter is related to same, my lord. Okay.
May I plead your lordship, listing of a matter for admission, your lordship.
Give a date.
May it please your
Can it be on 21st, okay. Oblige
With
your
consent from the respondents, lordship, I beg to mention item number 22 of today's list, lordship.
Yes,
Lordship, in this case, senior counsel, Mr. D.K. Mishra is appearing and he is unwell, recently been released from hospital. So matter may be taken sometime in the first week of December, lordship. In fact, lordship, I also submitted advance notice requesting adjournment.
okay, right. Adjournment prayer has been made. On the ground that Mr. D.K. Mishra, learned senior counsel, is not well. This is the matter when?
Anytime in first week of December, lordship.
Why first week?
Lordship, from 19th, we will not be here, lordship, already letter of absence. 10 days will be up.
This, give a date. This is the matter.
May please.
Oblige.
The petitioners will have to make submissions with regard to whether there is any alternative remedy.
May please. This is being for listing on admission matter, lord. Come upon 18, lord.
18.
May please, your lordship. In item number 14, already the new incumbent has been implemented, lordship. It is strongly listed, lordship. So we have not taken steps, we will take steps, lordship. To the new incumbent,
Only in 14.
only 14.
Okay, right, in 14. Mr. R. Dhar, learned counsel for the applicant, says that he may be allowed to withdraw the application. In as much as the respondent number 3, in as much as Mr. Akash Deep
Yes, yes.
has already been implemented as respondent number 3 in an earlier application, IA.
IA.
So, sir, the prayer of Mr. R. Dhar is allowed. The application is accordingly dismissed as withdrawn.
No.
Then, right, in the main case, in item 14, you write, Mr. R. Dhar shall take steps for service of notice upon the respondent number 3 within 2 days.
2 days.
List the matter after 4 weeks.
Deeply approved.
May please your lordships. My lords, with the consent of the other side, my lords, I beg to mention item number 6, my lords. I am seeking an adjournment on the ground that, my lords, outgoing counsel, Mr. I. Chaudhary, is undergoing some dental surgery today, my lords.
What surgery?
Dental surgery, my lords.
Dental surgery.
Yes, my lords. So he will not be appearing before my lords today.
Have you taken the consent of the other
Yes,
side?
my lords, from
Okay.
the IOC.
Your name is
T. Das, my lords.
Mr. T. Das, appearing for the petitioner. Prays for adjournment on the ground that Mr. I. Chaudhary, senior counsel, is undergoing a tendon operation today.
Third,
Accordingly, release this matter when next week?
dental,
Dental,
dental.
okay, dental, not tendon, dental. Accordingly, release this matter when?
any day in the last week of this month, my lords, because in the third week he will be in Itanagar, my lords. So any day, my lord, as per my lord's convenience.
Why this week, next month also?
In the first week of December, my lord, as per my lord's
Third.
convenience. Deeply obliged.
3rd December.
May I please, my lord? My lord, I'm praying for listing of a writ petition, my lord, for motion, my lord. Can it be listed day after tomorrow, my lord, 30? Okay. I oblige, my lord.
May please, lordship. I beg to mention item number 32, lordship.
32,
Lordship, this matter has become an influx of lordship.
32. Okay, yes. Mr.,
I am on behalf of Mr. A.M.S. Muzumdar, lordship.
what is your name?
Yeah, Hussain, lordship.
A.
Yeah, Hussain.
M. Hussain,
Yes.
appearing on behalf of Mr. A.M.S. Mazumdar, learned counsel for the petitioner, submits that the writ petition has become infructuous. Who appears for PWD? Mr. M. Barwa, M. Buyan, appearing on behalf of Mr. B. Ovoy, learned counsel for the PWD is present. The prayer of the petitions counsel is allowed. Writ petition is dismissed as infracted.
Please, my lord, I wish to mention my lord, item number 30. Item
30.
30, my lord. Maybe possible for the day, my lord.
Okay, who's for the other side? Water resource? Yes, Miss DJ come. Item 30. You have not filed an affidavit.
Lordship, today we will file.
You'll file it today?
Yes, Your Lord.
Okay, Miss DJ, Learned Counsel for the Water Resource Department submits that affidavit in the position will be filed during the course of the day. Accordingly, leave this matter,
Next,
leave this matter after the week.
Obliged, ma'am.
oblige.
May I please your lordship?
Due to a compromise,
Yes.
Mr. S. Sancheti, Learned Counsel for the petitioner, for the applicant. What is this? Okay, and
I has been filed.
for the applicant, prays that he may be allowed to withdraw the writ petition. Just say applicant slash writ petitioner. Prays that he may be allowed to withdraw the writ petition as a compromise has been effected between the parties. So Mr. A. Das Gupta, Learned Senior Counsel, appearing for the correspondent number. Correspondent number 3. Or correspondent number 3. 3. And Mr. K. Gogoi appearing for correspondent number 1. What? 1. Submit that the writ petition can be closed due to the above compromise. Full stop. Accordingly, the application and the writ petition are closed, are dismissed due to out of court settlement between the parties.
Hello, Blake.
May I please your lordship?
Yes. Who is appearing?
My lord.
Yes.
R. Musari was apparently there is some health problem. My lord, telephony instructed that the process of sanctioning or issuing of sanction order for release of money that has already started. Thereafter, it will go to treasury and then that. But his serial number, I have to check it up now.
Why didn't he come?
Well, he is having some personal difficulty. Why is he?
We'll list it again.
Lordship,
No.
let's take it.
Mr.
Wednesday, my lord.
Huh?
Wednesday? This one.
Well, let it be on next week, Monday.
Then yes, wait, madam, the things don't work as fast as we want. What do it? Submission has been made that Mr. R. K. Mushare, Learned Counsel for the BTC, is having some personal difficulty. Full stop. However, it has been submitted by Mr. S. Bora, appearing on behalf of Mr. R. K. Mushari, that the process for obtaining sanction and payment of the
Issuing sanction orders for payment.
and however, the process for issuing the sanction order for payment to the petitioner has
Not the-
been
not the-
initiated.
Not the petitioner, all the listed persons have started.
Anyway, naturally to the petition, one of them has been initiated. List the matter,
Next week, Monday.
give a date after 10 days or so.
Maybe 20, my lord, 20 of this November. Wednesday, that is.
Yes.
20.
List the matter on 20.
Oh, well.
Well, here I'm for the petitioner, my lord. Well, the respondent railway has filed, my lord, the affidavit, my lord, as per the direction of this honorable court, my lord. Probably that is not on the record, my lord. I have checked, my lord. Probably, my lord, it is not on the record.
No, not here.
Yes, my lord. So, my lord, can it be taken up to, my lord, if, my lord, not,
No.
my lord, anytime.
Where is the railways? Who is appearing for the railways? Huh? Huh? Mr. B. Chakrabarti is supposed to be here. Right. Yes, he's coming. Yes, yes.
Lordship, we have filed our affidavit.
And to what effect? To what effect?
Your Lordship has sought some clarification and we have also filed the reply to the
But so what have you said?
Lordship in Western Railway, Lordship. They run it departmentally, but Northern Railway, they for maintenance and escorting, they follow the RDSO. For escort only, they have relaxed that knowledge, Lordship.
No, no. So the issue is this. So the Western Railways are doing it as per Southern Railways.
No, they are doing it
Separate.
departmentally. They have their own. They don't.
They're not following your procedure also.
No, neither us nor there.
Okay, then Northern Railway are following the Southern Railways. And Eastern Railways are following?
We are yet to receive their response, Lordship. In any case, Lordship, that is not binding, but that our railway board's letter is give the Lordship discretion to the
Correct.
PCME, that is Principal Chief Mechanical Engineer. So that is not binding. And moreover, after this, Lordship, I have annexed in my affidavit, Lordship, about 5-6 tenders we have issued in which we have followed this rule, RDSO rule. And person has participated and they are getting doing the work, Lordship.
Malad, in this case, Malad, I am led by Mr. Sorry, Malad. Can it be taken up for some time, Malad?
No, not today, not today.
Malad.
Also, technical bid has been opened or not?
Lordship, your Lordship has
No, we have allowed the,
yes, Lordship.
we have allowed the tender process to continue
But-
till the stage of opening of the technical
But
bid.
it has not been finalized.
Has it been opened?
Perhaps open, but I will take the telephonic instruction, Lordship. That your Lordship has not restrained, Lordship.
No, I'm not restrained. That's why I'm asking you.
We have, perhaps,
So you don't know. So say that you don't know.
Lordship.
So it's you just have to say that. See, it's either yes, no, or don't know. That's all. Okay, right. With this sit next Monday. Take it up. Okay, right.
Malad,
Next Monday. No, I'm not free.
Malad, can it be Malad on Friday, Malad? Thursday, Malad. Malad, I will not be there on Monday, Malad. On Thursday, Malad, if possible.
Tuesday, let it be Tuesday.
Next Tuesday. Huh?
Next Tuesday. Tuesday.
Right.
Malad, next Thursday, Malad, I will not.
Huh? No. Thursday is not possible. I'm
Wednesday, Malad. Wednesday, Malad.
no.
Malad,
Sorry. We cannot go according to you.
Malad,
Heard, Mister.
I have already filed a letter of absence, Malad.
Your seniors appearing or you are
Yes,
appearing?
Malad.
What are you? What kind of argument is this? You are. Is your senior appearing on that? Not
Yes,
going to appear on that day?
Malad, he will not on out of station, Malad, probably.
If he's not, is out, you make some alternative arrangement. Otherwise, we'll adjourn the matter.
Malad.
Heard, Mr. G. Goswami, learned counsel for the petitioner. Mr. B. Chakrabarti, learned CGC submits that affidavit in the position has been filed
On last Friday, Lordship.
on 8/11/2024. Accordingly, this matter for this matter on
Next Friday, Malad.
this matter on Tuesday, next Tuesday. Or Monday, this matter on next Monday, 18th. On which date an attempt shall be made to dispose of the matter. In the meantime, the petitioner may file a reply affidavit, if so advised.
Malad, interim may continue, Malad. Interim may continue, Malad.
Interim order to continue till the next.
Malad.
May I please, Lordship? Lordship, nothing.
Acha, Mr. Goswami, are you filing any reply? No. Acha, just say, Mr. G. Goswami submits that. No reply affidavit is going to be filed by the petitioner. Yes, item. Heard, Miss
D. Angana.
D.
Angana. In the cause list, name is there.
D. Angana, learned counsel for the petitioner who submits that the petitioner's contractual dues amounting to rupees 89,201 has not been paid. When did you complete the contract?
Lordship, come to page number 17 of the affidavit. We have filed a copy of the bill. Bill was of dated 3/2/2017. Before that, the work was completed, and here it was written also, account of work done.
So when was it completed?
It was completed before 3/2/2007.
Before 2007 can be BC also,
Oh, Lordship.
or maybe 200 years back also. When? Could be from Independence Day also, we do not know. When was it completed?
It was date of starting was 29/3/2016.
Okay, right. Issue notice returnable in 5 weeks. Ms. D. Jain, accept notice on behalf of
Water Resource Department.
all the respondents.
Yes, sir.
List the matter after 5 weeks to enable the respondents to file their affidavit.
Lordship, item 5 is the same.
In item 5, the amount will be 342,342. 342,342, okay? Same.
That's marvelous, Lordship.
My lord, in item number 7, my lord, there has been disposed of matter, my lord. In last occasions, my lord, the disclaimer called for that, my lord, the order passed in that item number 7, my lord, would dispose of matter, my lord. The it was alleged that a pending requisition was not mentioned, but in the paragraph number 8, my lord, of the disposal of matter, my lord, it was mentioned, my lord. Disposal. Oh, 85 of 21, my lord. Paragraph number 8, my lord. Though it was not reflected in the disposal order, my lord.
Mr. Counsel, you were asked to vacate, correct?
Yes,
Why were you asked to vacate?
my lord, in 2980, my lord.
Tell me, why were you asked to vacate?
Yes, my lord. There was an allegation for my lord regarding construction, my lord.
Unauthorized construction. Unauthorized construction allegation was made against you.
Yes, my lord.
Ah,
Yes.
when? Which year?
My lord, it is my 20, my lord.
2020, correct?
Yes.
Now, after 2020, you filed your first writ petition, correct?
2020, I filed first.
First writ petition
20.
filed 2020. What
Yes.
is the writ petition
My
number?
lord, 2980, my lord.
2980 of 2020. What is your prayer in the 2980 of
Yes.
2020?
Prayer page number 9, my lord.
Challenge the eviction order.
The notice
Challenge
was,
the eviction order.
yes, the
Correct.
notice was challenged, my lord. Page number 9. Notice was issued in 2020,
Now,
my
so this is still pending. What is this?
yes, my lord. No affidavit is filed, my lord, till date, my lord.
Now, thereafter, you filed 85 of
Yes,
2021.
Yes, my lord. Pending this.
And out here, what was your prayer in 85 of 2021?
Yes, my lord. Due to the dilapidated.
What was your prayer?
Yes, my lord. Page number 9, my lord.
Now to construct and renovate. the
Renovation,
building.
my lord. That was the renovation prayer, my lord. And paragraph number 8, my lord. Kindly, my lord, see paragraph number 8. The pending liquidation was disclosed, my lord, in that petition, my lord. And the honorable court, my lord, allowed the my lord renovation, my lord.
That temporarily, only for temporary.
Yes, my lord. Yes. So, my lord, since the main petition is pending, my lord, and no affidavit is filed till the last 4 years, my lord, let the notice may be issued and affidavit may be filed, my lord. Then your lordship will decide, my lord, the on the basis of the affidavit, my lord. Since no response is there, my lord, from the respondent side. my lord.
Yes, what to do? You issue notice.
My lord, the strength of the earlier petition of 2020, my lord, the lease agreement, and that is already over, my lord.
Correct.
Lease period is already over. Now the only issue is whether their lease will be renewed or not. That issue is only
And the period was over in 2021.
Okay.
Now whether he can come at this stage
Yes, sir. That is
after 3 years.
That is the issue.
That may be responded, my lord, that may be affidavit filed on my.
Right. Heard Mr. M.J. Kadir, learned counsel for the petitioner. The petitioner's 5-year lease for bit number BHIT, bit number 17 in Nutan Bazar ended on 28/4/2021. The petitioner has filed the present writ petition on 22/10/2024. That is 3.5 years after the expiry of the petitioner's lease period. Praying for an extension of the lease period. Prima facie, it appears that it appears that there has been considerable delay on the part of the petitioner in praying for extension of the lease deed, which expired in April 2021. Next paragraph. The petitioner has also put to challenge the eviction notice dated 6/7, eviction letter dated 6/7/2020 in WPC 2980/2020. And while interim order dated 7/8/2020 had and this court, while interim order dated 7/8/2020 had directed the state respondents not to disturb the possession of the petitioner in respect of bit number 17 until further order. It appears that the petitioner is still in possession of bit number 17 beyond the 5-year period. And as such, it appears that WPC 2980/2020 is infructuous.
My lord, may I submit one point, my lord? Clause number 6 of the, my lord, lease, my lord, kindly see page number 11A. There is a specific, my lord, clause that the lessee shall renew the lease on completion of the 5 years, my lord. The clause is there, my lord, regarding renewal, my lord. On the basis of that, my lord, this petition is filed, my lord.
Why you did not pray earlier for renewal of your lease?
Earlier, my lord, I have approached on several occasions, my lord, due to the.
You could have always gone in that earlier writ petition of 2020.
Yes, my lord. That was due to pendency of the that petition, my lord. They are not renewing, my lord. That was the answer, my lord. I have specifically averted, my lord, in this petition, my lord.
Anyway,
Kindly, my lord, kindly produce the, my lord, petition, my lord. Paragraph. I have specific abarment, my lord. That due to pendency, my lord, page number 8, paragraph 12. My
what to do, Mr. Data? You'll file an affidavit.
My lord, I can file my lord.
Because in the earlier writ petition also you have not filed.
Yes. The instruction is here, my lord.
Okay, you file your affidavit, we'll dispose of the entire.
My lord.
Issue notice. Returnable in 4 weeks. Mr. Data accepts notice on behalf of all the respondents.
Three, my colleague is there, my lord.
All the respondents except respondent number 3.
My lord, 6 I can't appear, my lord.
Okay, Mr. Data appears for respondents number 1, 2, 4, and 5.
And 7.
1, 2,
5 and
4,
6.
5, and 7.
My lord, in fact, I have to inform that, my lord, 5 and 6, they are no longer holding the president post. Because the election is still not done, my lord. There is no president at this time.
Okay. Mr. Datta submit, accept notice on behalf of respondents number 1, 2, and 4.
2, 4, and 7.
1, 2, 4, and 7. First off, he submits that there is no precedent of the Narsinghpur Ancharik Panchayat or the Clever House Gaon Panchayat as on today. First off, as such. No, first off, that's all. Mr. K. Gogoi accepts notice on behalf of point number 3. The respondent shall file their affidavit within 4 weeks. This is the matter of the 4 weeks. No, in one only. That's the only one precedent. They want to already make it. Wait just a minute. What about 2980 also? That notice already.
Yes.
Already.
My lord, I'll file affidavit in 2980, my lord, old one.
Oh, okay, whatever.
Yes, yes,
whatever.
yes.
You file in both.
My lord, both, my lord. Oblige.
It will cover both anyway.
My lord, my lord.
Supplementary motion 45.
My lord,
Yes, Mr. Datta.
my lord.
Settlement already made. Petitioner has been operating the market for 2 months. So how will that,
Particular,
how can this notification
yes, yes.
does not cover this kind of case? It only covers cases where settlement has not been made. Because if you read the notification
My lord,
at page, where is that notification at
45, my lord.
45?
45 and 47, my lord.
No, not this.
47, my lord.
47
It's gonna go.
is to please to cancel the ongoing process of settlement.
Yes, ma'am.
This is not an
This is
ongoing
settled.
process, this is settled already. Right. Heard Mr. M.K. Boro, learned counsel for the petitioner. Also heard Mr. S. Datta, learned counsel for the PNRD department. The petitioner's case is that, you take this, huh? Last order from here. Is that from here? From here. In para 2 also you take, okay? Para 2 also. Then next you write Mr. M.K. Boro, the learned counsel for the petitioner submits that a perusal of the impugned notification small e, capital CF, number 221100, dated 29/6/2024, issued by the Principal Secretary to the Government of Assam, Panchayat and Rural Development Department, only pertains to the cancellation of the ongoing process of settlement of huts / ghats / fisheries / pounds, etc. for the year 2024-2025, for which NITs were already floated. It does not cover cases where the settlement has already been made by the state respondents
May I submit one?
with the successful tenderers. Yes.
My lord, although the proposal was issued on 26/6/2024, but they have to show, my lord, whether before 29/6 they deposited the amount, my lord.
No.
Because to establish the
Settlement order has been issued on 26/6/2024. This is
26 is the
ongoing process of settlement. Settlement order has been issued on 26 prior to 29, 3 days prior to the order.
This is only proposal, my lord.
No.
This is only proposal. If he
Let us
deposits
see.
the money, then only.
Let us see. Where is the, let us see the settlement order
Well,
page.
Page 36.
Huh?
36, my lord.
36 is the translated version, my lord.
Okay, on fulfillment of the condition.
Yes, my lord. They have to deposit the money, then only contract will establish completely. Because lease agreement,
When did you
It's not signed.
submit all the, when did you fulfill the conditions?
My lord, as per my instruction on the same day, my lord, 26th.
Where have
Sir.
you said that?
Yes, my lord.
because page number 41, my lord. Money deposition slip on 3/7/24.
It is the first kiस्त, my lord. First month's installment. Bazaar was at the monthly basis, my lord, at 35,000. It was 39,500. I deposited on the month of 3/7.
Let us see all the, where have you written?
Because this kind of similar cases are also pending with the series, my lord. Exactly similar. Or selected but not paid. 2-3 cases are there in the series, my lord, listed for tomorrow. They are also on the same footing.
Selected but not paid
Is
the
not
amount.
paid, therefore cancelled. On the process,
Okay, so we list it tomorrow.
Yes, yes,
We list it
that-
tomorrow, Mr. Council.
tomorrow is
Well,
series.
List this matter tomorrow. Don't call them.
Obliged.
46.
This is with regard to the retail outlet, the dealership.
Before my significant starts, I'm not authorized to make a submission on behalf of the IOC. I'm not empaneled, your lordship. If the matter can be taken up by Wednesday or Friday, my senior, along with the meeting counsel for the IOC, is not present today. I cannot make a submission on behalf of the IOC. The matter can be taken up on Wednesday, subject to my friend's convenience also, and my lordship's convenience.
Otherwise, I have no problem. The only thing is if they don't issue it to someone else.
I understand. I've
Only thing,
seen
otherwise, Wednesday, no, I don't have.
They won't issue, I think.
Wednesday, your lordship.
So here on page 152 is the,
Yes.
so it says here offered land is on long-term lease registered on 17/10.
Yes.
Our lease deed is effective from 18/10.
It was a mistake,
Okay.
will be corrected next day. That day itself, then we submitted also. Provisionally was selected. They did not raise any objection. Now the provision is that I can offer till 90 days, I can offer the land matter. So they are now saying that you are not entitled.
In 90 days, you can offer alternative.
Alternative land. It's not a question of even alternative, offering alternative. That was only mistake in the correction of the deed, my lord. It was instead of 17, it was written 18. We corrected the same day, my lord, and uploaded it also. And was informed to that. And they provisionally selected this thereafter, my lord. They inspected the land, my lord. In fact, they verified the other documents also. Now, when I wrote to them, my lord, saying that you are delaying the matter, I've already spent 10 lakhs rupees. Then thereafter they issued this notice, my lord, saying that you are not eligible, my lord. That land offered is not
Fair enough.
suitable.
I have no objection to the submission they have made.
Okay, right. Heard Mr. M. Datta, learned counsel for the petitioner, who submits that the petitioner submitted his bid for allotment of retail outlets, including, no, which, how many
One.
submitted his bid
My lord.
for
S6,
allotment of retail outlet
my lord.
at
Location.
location bracket invert commas SH-1
Yes.
between Salkat Tea Estate to Titlaghat invert commas code, comma reserved for ST category candidates. Full stop. The petitioner was provisionally selected for the said retail outlet. However, due to a clerical error in the lease commencement date in the lease deed offered by the petitioner, comma 18/10/2023 had been typed instead of 17/10/2020. though the said mistake was corrected on the same date, that is 17/10/2023, comma, the state respondent, but the IOCL or what?
ISL, my lord.
The IOCL, wide letter dated 24/10/2024, bracket page 50, page 152, huh?
Yes.
Has informed the petitioner that he was found ineligible for being selected under the Group 1 category. The petitioner's counsel submit that the typographical error having been corrected by the competent authority on the same date itself, that is 17/10/2023. And in view of the fact that the petitioner was to be, could have been given 90 days time for for
Alternative land, my lord.
for
Providing alternative land.
providing alternative land, comma, the impugned letter is arbitrary. Issue notice returnable in 3 weeks. Mr. M. Sharma appearing on behalf of Mr.
MK
No.
Chaudhary.
He cannot accept.
I'll accept.
Mr. M. Sharma, accept notice on behalf of the respondents number.
1, 2, and all the responses. All the responses.
Accept notice on behalf of all the respondents. This is the matter. After 3 weeks, to enable the respondents to file their affidavits. In the interim, the respondents are directed not to issue any letter of intent for the retail outlet at location SH-1 between Salka Thoni Tea Estate to Titlagar in favor of any person.
47. Material Lordship, this product is a third occasion when it is come.
That division bench has not decided.
No, not yet decided. Your Lordship, we have come. Initially, they said that no NIT was issued. It was given to third person, the third party. It was taken. Again, they have issued that NIT.
Okay.
Your Lordship, kindly your Lordship's order, page 75.
Order is in page 75.
Page 75. Yes, ma'am. Page
Okay, right.
75.
Which NIT are you challenging?
Yes, page, NIT is page 50
Okay, right.
for 2 months.
Heard Mr. H.R.A. Chaudhary. Learned senior counsel for the petitioners
Yes, petitioners.
assisted by Mr.
Yes, Islam.
S. Islam.
Madam.
Learned, Okay, this page 75 to 77 same, except NIT
Dated
dated
24/10/24.
24/10/24, huh? NIT dated 24/10/24, only that. Then okay, issue notice, it's here. Who accepts notice? Mr. K. Gogoi accept notice for respondent number 1,
I am for 2 to 6.
while Mr. G. Bokalial accept notice on behalf of respondents number 2 to 6.
Notice completely.
2 to 6.
Will supply copy.
Then that's all. So everything will be same except para 5 will be changed.
Obliged.
It's, I don't know, it's written here.
No, see, finally, actually, this matter for 4 weeks, I have to take instruction whether the matter is still surviving or not. And if it is surviving, allow me to take step on the respondent number 6, press steps. Contact number is also not working, Lordship. I think I have to send a letter to the petitioner, Lordship.
Mister, I don't think anything survives in this writ
Yes,
petition.
so then also, Lordship, let me take the instruction.
What instruction? This, the settlement of the fishery was for 7 years. It ended in 2021.
Yes, Lordship,
You are asking for extension of the fishery.
Lordship.
Now 3 years, 4 years have gone.
That's
There's no
okay.
extension has been given. Where's the question?
Lordship,
What right have you got?
I have challenged the settlement order to the petitioner, respondent number 6 also, Lordship.
When was, and it was settled for which period?
For up to 31st of March 2022, Lordship.
22.
Yes, Lordship.
Period has ended. Finish.
Thereafter, Lordship, what happened, I don't know. And 2 weeks, Lordship, at least.
No.
At least, Lordship, 2
You
weeks.
go to the division bench and challenge this order. I'm going to dismiss your case. There's nothing left. Yes, what?
I'm appearing on behalf of peace and he's in legs, you know.
Okay, we'll wait for some time. You just wait. What is your name?
AD schedule, Lordship.
Mr. A.D. Chaudhary appears for
Petitioner, Lordship.
the petitioner. You be there. You be there when Mr. P. Sharma comes. There's no case left.
The party item 11.
May I please introduction? Actually, we are praying for implement of the applicant in the petition number 2729 of the.
Impediment.
Yes,
Mr.
DJ Mehdi.
DJ Mehdi, learned counsel for the applicant. Yes, any objection? Mr. DJ Mehdi, learned counsel for the applicant. Praise that. The who is the applicant? Who has to be impeded? Please that MS Pat Bausi Min Samaibai Samiti being represented by it is here, huh? In page 3 of the application should be impeded. Who should be impeded as respondent number?
Respondent 6, my lord.
You not even made that. Well. Point number 6.
In the prayers, we have mentioned, my lord. In the prayers.
You have not said respondent number 6.
Implemented as party respondent 6 in the connected petition being WBC number 2729 of 2020.
Who appears for the other side? Mr. Huh?
K. Mohammed.
K.
Mohammed.
No, not here. Your name is not.
It's there.
It's here.
Yeah.
Mr. K. Mohammed
Yes.
appears for the writ petition and submits that he has got no objection to the same. Accordingly, so and so is implemented as respondent number 6. Applicant to submit a corrected copy of the cost title to the registry within a week. The application is accordingly allowed and disposed of. Next paragraph. Then in the main case, you're right. In view of the order dated 11/11/2024, passed in IAC 3096 of 2024, so and so is implemented as respondent number 6. Issue notice to the respondent number 6. Petitioner to take step, no. Who will take step?
I can serve no copy.
Acha. No, issue notice, don't say that. Just a petitioner to serve a copy of the writ petition to the council for the respondent number 6, who is represented by Mr.
DJ Mehdi.
DJ Mehdi. List the matter after. How much time do you want to file? List the matter after 2 weeks to enable the council for the respondent number 6 to file affidavit.
Much.
Item 12.
May I please, Lord? My lord, page 3, my lord of IA, my lord. Opposite part number 1 and 2.
Any objection, madam?
No, Lordship.
Mr. A.H.M.R. Chowdhury. Praise that. Mr. Amin Uddin,
Lordship.
son of late Ayub Ali.
My lord, Aminuddin is applicant, my lord.
Is the applicant. Who is the one?
Yeah, my
Two and
lord.
three, no?
Yes.
Mr. Ranjit Kumar Laskar. So and so, huh? And Mr. Mohsin Siddiqui, okay? So and so should be included as respondents number
7 and 8.
7 and 8. Miss
J. Bora Lordship,
J. Bora,
on behalf of S. Dr. Lordship, PNRT,
on behalf of Mr.
S. Dr.
S.
Lordship,
Datta, counsel for the PNRD department, and Mr. A. Bhattacharjee appearing on behalf of respondent numbers
1 to 4, my lord.
1 to 4. Submit that they've got no objection to the implement of the above persons. According so and so are implemented as respondents number 7 and 8. Applicant to submit corrected copy of the cost title to the registry within a week. The I is accordingly allowed and disposed of. Then in the main case, you write in view of the order dated 11/11/24, passed in IAC 3200 of 2024. So and so are implemented as respondents number 7 and 8. Issue notice to the respondents number 7 and 8. Petitioner to take steps for service of notice upon the respondents number 7 and 8 by registered post with AD within 3 days. This is the matter after 4 weeks.
Within 1 week, my lord. In the meantime, I have to submit the cost title, my lord, a corrected cost title.
Okay, within
7 days, my lord.
7 days. This is the matter after 4 weeks.
Public.
Bless Lordship.
Time being 9 and 10. Sorry, 9 and 10.
Yes. No reason of giving extension lordship. Already we have settled to somebody lordship.
Already settled
Already
with the respondent and with another new person.
New person, by way of tender lordship.
When? By what? Tender.
Yes, he was supposed to take steps on the new lessee lordship.
Okay.
Lordship,
So a new lessee has been, so that respondent number, challenge to respondent number 6, that has ended 22 in day
yes,
22.
Yes,
So now a new tender has been floated.
yes, new tender is important.
Can you tell me the tender date and the person to whom it has been?
Yes, it is here. Lordship.
Without tender, that was settled with respondent number 6, Lordship.
Mr. Council, that has finished.
That has finished. Now we have
That is finished.
nothing. Now we never settle anybody. So it can be up to another matter. Is that?
Okay, we'll take it up at 2. You find out the thing.
No, I will give it.
There's nothing here. There's nothing remaining. There's no point keeping all these cases pending.
First, Lordship, 1 week time, Lordship,
No,
to get me the instruction.
no. You obtain instructions now. Call him by phone. Call him by.
It's not working, that's why, Lordship.
Then 1 week nothing will happen. Unless you're going to take a walk to his house or something like that. Nothing will happen. Right. Okay. Heard Mr. A.K. Hussain, learned counsel for the applicant who submits that Mr. Indranil Barwa, Superintendent of Police, Hamren, West Karbi Anglong District, Assam 782460 should be implemented as respondent number
Only sole content, new content,
should be
new concept.
implemented as respondent number 2.
Well.
Huh?
Not
You
actually,
should substitute.
my lord.
Should be implemented and allowed to substitute the respondent Sanjeev Kumar Shaikya, who has been transferred out.
Well.
The prayer of the applicant is allowed. So and so is implemented as respondent is implemented and allowed to substitute the earlier respondent. Applicant to submit a corrected cost title to the registry within
7 days.
within 7 days. I is accordingly allowed and disposed of. Then in the main contempt, you write, in view of the order dated 11/11/2024, passed in IAC 3339 of 2024. So is impleted as respondent number, is impleted and allowed to substitute the earlier respondent, Shri Sanjeev Kumar Saikya. Issue notice returnable in 5 weeks. Petitioner shall take steps for service of notice upon the respondent by registered post within a week. This is the matter after 5 weeks.
Item 15.
Next, please, Your Lordship. I'm pleading of new.
Akashdeep. Okay, heard Mr.
Bisim Sahari, Lordship.
B.C. Mushahari, learned counsel for the applicant, who praised that Mr. Shri Akashdeep Principal Secretary, Bodoland Territorial Council, Bodofa, Ngor, Kokrajhar, PTR, Assam 783370 should be implemented as respondent number 3. Ms. R.B. Bora, appearing for the respondent number 2, submits that she has got no objection to the thing. Accordingly, Mr. Akashdeep Spencer is implemented as respondent number 3. Applicant to submit a corrected copy of the cost title to the registry within a week. The I is accordingly allowed and disposed of. Then in the main thing, in the main content, right? In view of the order dated 11/11/2024, passed in IA Civil number 334 of 2024. Shri Akashdeep Spencer is implemented as respondent number 3. Issue notice to the respondent number 3, returnable in 5 weeks. Petitioner to take steps for service of notice upon the respondent number 3 by registered post within a week. This is the matter of the 5 weeks.
Lordship, maybe 4 weeks. ma'am.
Then you file the cost title within 2 days.
Yes.
Okay, right. In the IA, you write that corrected cost title within 2 days. Then out here, in the main contempt, right? Issue notice returnable in 4 weeks. Okay, then this is the matter after 4 weeks.
Item 16.
Lordship, same Lordship.
Same order.
Applies.
Item 18 for admission.
May it please your lordship, in this matter, we are the newly engaged counsel.
Huh?
We are the newly engaged counsel in this matter.
Okay.
Lordship, some time may be granted.
Okay.
Lordship, last listing date is 4/6/18, Lordship.
So,
They may be directed to file their affidavit.
Mr. You see, it was last listed 6 years ago.
Yes, Lordship.
So she has got no idea. That time probably she was not even in the profession. I don't
Yes,
know.
Lordship.
Okay, right. Ms. D. Jain, learned counsel for the Water Resource Department, is given
3 weeks.
3 weeks, 4 weeks time to file affidavit in opposition. In as much as this case has been listed today after 6 years of the last listing, that is on 4/6/2018. This is the matter after 4 weeks.
Applied, sir.
21.
Yes, are you making any application for implement?
Lordship, I have been allowed to file amended cost title. Accordingly, I have filed amended cost title. And forest.
No, amended cost title.
Lordship.
You see, you have got to file an application for implement first.
Implement. Lordship, next paragraph, the petitioner may file amended cost title before the registry within a 15 days.
No, this is wrong.
Accordingly, we have.
How can it be? We have got to follow the procedure.
This-
Unless there is there any order impeding them? Is there any order?
This order, Lordship.
No, no.
Order dated 29.
No, where is the order of the court saying that they are impleted as respondents number so and so?
Lordship,
This is a mistake committed by this court. This is a mistake.
I cannot comment, Lordship. But
No, no, you know very well. You have been practicing for how long?
Lordship, I got your point, Lordship.
Unless, you see, and that earlier practice of impleading parties by order of the court, now that cannot be done as per the notifications issued by the High Court. Cannot be done. There has to be an application because it cannot get uploaded into the system.
That was the appropriate procedure, Lordship. Lordship is correct.
So please follow.
But at
Maybe, but then it was your duty to assist the court.
No, at that point of time, the matter was brought up, Lordship, when court has passed this order. And when the court is passing the order, Lordship, we normally, Lordship.
You see, we also make mistakes at times.
Yes.
Judges are also humans.
Yes.
To err is human.
Lordship, at this, now, Lordship, we have filed amended cost title, Lordship. If Lordship allow me to, or otherwise I can file amended petition, otherwise.
You please fight. It will not be correct.
Because then Lordship may pass an order to.
You see, it says here, accordingly, the petitioner is permitted to implead the forest department under the concerned revenue circle officer as the party respondent
Yes.
is permitted to implead.
And
It
next,
doesn't mean that it is impleaded.
next paragraph.
The petitioner may file amended cost title before the registry with the This is there's a mistake committed. So, yes, you can know from very well from it. It's a mistake committed by this court. A copy of the amended cost title be furnished. No, cannot. Unless has to be an order impleading them first by this court. There's no order impleading them.
Now Lordship has, registry has also accepted. So Lordship pass an order.
Okay, right. Mr. P.P. Datta, learned counsel for the petitioner submits that in terms of the order dated 20/09/2024 passed by this court, the petitioner has filed an amended cost title before the registry, whereby he has impleaded the forest department as well as the concerned revenue circle officer as respondent numbers
4, 5, and 6, Lordship. Respondent
4, 5, and 6. Full stop. The next para. The relevant portion of the order dated 20/09/2024 passed by this court is as follows. Between pencil. Accordingly, the petitioner is permitted to implead from here till list accordingly. Okay, till the end. Okay, this. A perusal of the above clearly goes to show that there is no order passed by this court impleading the forest department or the concerned revenue circle office. The order only permits the petitioner to implead the forest department and the concerned revenue circle office. The filing of an amended cost title before the registry without the parties being impleaded. No, the order allowing the petitioner to file the amended cost title without impleading the parties, aforesaid parties, is a mistake. And as such, this court is of the view that unless the parties are impleaded, by way of an appropriate application and order of this court, filing of an amended cost title would not serve the requirements for impleading the parties, the aforesaid parties. Accordingly, the petitioner is allowed to file an application for impleading the forest department as well as the concerned revenue circle office. This is the matter after
4 weeks.
4 weeks.
Obliged, Lordship.
Obliged. 23.
Okay.
The last occasion, the study council takes time for instruction in this program. 410.
Yes,
If this matter can be disposed of, since we have not received instruction, let the authorities verify. They can
Okay,
put it as
right.
what I'm saying.
Mr. AK Data. Mr. DC Nath appears for the petitioner, while Mr. R.R. Gogoi appears for the PhD. The petitioner's case is that he was allotted work orders on different dates for installation of TARA hand pumps and RCC ring wells for village areas under various Gaon panchayats, issued by the executive engineer, Public Health Engineering Department, Dhubri Division. The petitioner completed the works allotted to him and thereafter prepared bills totaling how much?
2 lakhs 11
2 comma 11 comma
246.
246. However, the said amount has not been paid to the petitioner till date. He accordingly submits that a direction should be issued to the respondents to pay to the petitioner his unpaid contractual dues. Next paragraph. Mr. R.R. Gogoi, Learned Counsel for the PhD department, submits that no instructions have been forthcoming from the department, the matter can be disposed of by directing the respondents to verify the claim of the petitioner, and if the claim of the claim of the petition is found to be true, payment can be made on the admitted amount.
As per terms, sir.
In terms of Shamsher Ali versus Union of India, reported in 2008,
I'll give the citation.
1 GLT. 1 GLT. Next. I have heard the learned counsel for the part. The petitioner's contractual dues, as claimed by him, as claimed by his 4 bills, are as follows. That is here in the synopsis. 4 bills, 1, 2, 3, 4. Okay. This writ petition has been filed on 27/8/2019. And this court, while order dated 6/9/2019, had issued notice which was accepted by the Learned Standing Council PhD on 6/9/2019 itself. Despite more than 5 years having elapsed, the respondents have neither filed any affidavit in this court with regard to the claim made by the petitioner, nor have they given any instruction to their counsel. Accordingly, in view of the above reasons, this court is of the view that a verification should be undertaken by the respondent number 2 with regard to the claim of the petitioner's bills. If the claim of the petitioner, if the bill of the petitioner, bills of the petitioner are found to be correct, the respondents should pay to the petitioner the admitted amount. So the entire exercise should be concluded within a period of 3 months from the date of receipt of a certified copy of this order. The writ petition is accordingly disposed of.
Notice was issued in this case, Lordship.
Case
pertains to non-payment of contractual bill, Lordship. VPC is also there.
Lordship, our name not shown in the post list and perhaps copy also not served, Lordship.
Perhaps.
Lordship.
On last occasion, Lordship.
2020, repetition file in 2020.
But how can we know, Lordship, that name not?
Anyway, because the amount is huge, I will be careful here.
Lordship, then.
I think a few crores,
Yes,
nearly 5 crores.
yes.
Some other.
3 crore
some,
already paid, Lordship.
3 crore only paid.
Some video.
And there's also mosquito nets.
Yes.
Some DDURI appear for BTC. We do not know who is DDURI.
Okay, anyway, I will give you time, madam. Mr.
A Ganguly.
A. Ganguly appears for the petitioner. He submits that the petitioner had been issued supply orders in the year 2017 for supply of 40,983 mosquito nets. For distribution to beneficiaries under the BPL families through the DRDA of Kokrajhar, Chirang, Baksa and Udalguri, is it?
Yes.
Udalguri. The bills of the petitioner amounted to rupees 4,99,99,260. 99 twice, huh? Okay. Though the petitioner was paid rupees 3 crores, the balance amount of 1,99,99,260 has not been paid to the petitioner till late. Ms. R.B. Bora appearing for
2, 3,
2, 3, and 4.
2, 3, 4 submits that she needs time to obtain instructions in as much as she doesn't have a copy of the writ petition at this stage. Ms. J.
G. Kora, Lordship, respondent number 1.
appears for his point number 1. On perusing the writ petition, it is seen that the writ petition was filed on 12/6/2020. And this case has been listed in this court only once, that is on 22/6/2020. This is the second time the case has been listed in this. In view of the above, the counsels for the respondents are granted 4 weeks' time to obtain instructions. In the meantime, the petitioner's counsel shall furnish extra copies of the writ petition to the counsel for the respondents during the course of the day. List the matter after 4 weeks to enable the respondents' counsel to obtain instructions and file affidavit if necessary.
Lordship, names shall be shown in the post list, Lordship. 27.
A registry to reflect the names of SC, BTC and SC, PNRT in the cause list.
29 is the 28 is a contempt, Lordship, and 29 is the merit petition. Here, Lordship, the
Yes.
Lordship, petitioner was allocated some works by the BTC authorities, and petitioner has completed the work. After completion, the work completion certificate has been issued. Final bill was not paid. After inquiry, he came to know that for the same work, another person has been allocated subsequently by the executive in the Tongla division. And he has prepared the bill for payment to the balance amount to the other contractor. Finding no alternative, petitioner approaches court, and this court has passed an order not to release the balance amount to the contractor. Said order was served to the office of the executive in the Tongla division immediately after passing this order.
But still paid.
Still paid. Stating that the person who has received the notice has left the office for sickness, for child sickness, and that is why he was not aware of the payment, release of the amount.
And thereafter, Lordship, this court has to pass an order regarding the status of, regarding the make an inquiry by the BTC authorities. They have made an inquiry and submitted a report. They said that subsequently one tender notice was issued for the uncompleted works, and accordingly 2 persons were elected the subsequent work. This tender notice was published in a local newspaper published in Udalguri, and that earlier work order issued by the BTC authorities by the BTC head. Now executive engineer, who is also involved in criminal cases regarding the same division, he was arrested and he has made all the elements.
Now, what is the amount that was paid to them?
They have filed an affidavit and they have stated already they have released some amount. One amount was still lying. Their affidavit has been filed, Lordship will find. We have, they have not filed affidavit. And
How much is the amount?
amount is
Anyway, who has done the work?
one Pradeep Boro and one Diganto.
No, I'm not on that. I'm on who has actually done the work.
Lordship, in fact, as per the court's order, honorable court's order, there is the inquiry, Lordship. And as per the inquiry report, Lordship, he has annexed in his additional affidavit also, Lordship. The petitioner already received the money, whatever he has done, whatever work he has done, he has received. And after, when he has not completed the work, another contractor,
Two persons,
Lordship.
6 and 7.
Yes, Lordship. They allotted the work and they completed the work, Lordship. And whatever amount work he has done, he got that.
Okay, so that work was done by them.
Lordship. Subsequent work has been done by the other party.
Only problem is that order of the court that it should not be released. That
Lordship,
has been disobeyed.
I'm sorry, Lordship. In fact, Lordship, I have filed a detailed affidavit in this case, Lordship. The concerned executive engineer has had no knowledge, Lordship, of the order.
Yeah, he has knowledge. Probably he wanted some, maybe he wanted a little bit.
May not like so, may not be like so, Lordship.
Maybe he had some interest.
May not be like so, Lordship, but because it seems genuine, Lordship. In fact, the lady who was the dealing assistant, Lordship, she left the office, Lordship, immediately putting the orders in her, Lordship, drawer. And Lordship, after 7 or 8 days, after admitting her son in the hospital.
So at the end of the day, that work for which payment has been made to the respondents number 6 and 7, that work has not been done by you.
I have submitted the completion report issued by the authority. I have completed.
Let us not get into procedure or technicality. I am straight away, this be straightforward. You did not, that portion of the work for which payment has been made to the respondents number 6 and 7.
According to them, was not done by you. Correct?
And as per the inquiry report also, Lordship.
Huh?
As per the inquiry report, which was done on the basis of the order passed by the honorable court, Lordship.
So in that context, writ petition is infracted.
Lordship.
In that context. Only thing that will remain is with regard to the contempt.
Besides this, Lordship, may I submit one thing? What they have stated, they have cancelled my work order for uncompleted work. I have made a categorical statement that no notice was served to me regarding cancellation of the work order in my favor. Let them produce any document that they have cancelled the order by issuing notice to me.
No. Whether they issued notice to you or did not issue any notice to you, as on date, the entire work has been completed by you and the respondents number 6 and 7.
Yes.
As on date, has it been? Please understand.
Understood.
If the work has been completed, supposing we say, okay, no notice was issued to you, and the termination is wrong. Now, what can you do? You cannot go and do a completed work again. You cannot complete a completed work.
I do not want to complete the work because work has been completed in all respect. They have given a report.
So that way you can file a damage suit if you want.
Lordship,
As
that
per
is- that
Supreme
is why,
Court
Lordship.
judgment.
That is why, Lordship, I can file a damage suit
Huh.
with liberty to
liberty of published honorable court. Because limitation for filing appeal by this time has expired. If we obtain the liberty, then we can approach the civil court for damage. Only thing is, Lordship, they have given a report to me that I have completed the work in all respect and they are doing it successfully. I have annexed the report, completion report.
Lordship may seek page 117, the completion certificate, Lordship. It is not in respect of the petitioner, Lordship. There is no name mentioned, Lordship, that he has completed the work.
I have filed affidavit to that effect. Let them file an affidavit. I have not completed the work. Till date, they have not filed an affidavit stating that I have not completed the work.
Let us see 117.
117, Lordship.
Page 65 of the petition.
117, page 117. Completion, this completion certificate.
This is to certify that the scheme Ahu Band FIS taken up under AIBP for the year 2012-13 has been physically completed.
Correct. Completed by whom?
This is not there, Lord. He is saying he has completed, Lordship. We are saying, Lordship.
Page 65.
No, you are saying that because he did not complete the work, the contract was terminated and respondents number 6 and 7 were
Yes.
made to work.
Yes, sir.
Where is that? Where is that reflected?
In this completion certificate, this is not here, Lord.
Mr. Council, you are making submissions on the basis of what? Is it on the basis of your pleadings? Is it on the basis of the inquiry report? On what basis are you making?
My friend is appearing on.
What do you mean my friend is appearing? You are making all the submissions. I'm asking you to substantiate your averment, your pleading, your submission. You're saying my friend is appearing. Now, why did you make those submissions?
Lordship, may kindly see page 118, Lordship.
Yes,
Last paragraph, Lordship.
yes.
That as per statement of Sri Khatcharam Kolita, the then executive engineer, Tongla Irrigation Division, Tongla, who is recently transferred.
Just a minute.
Lordship.
That was a statement of case here.
Lordship.
This is my affidavit. Lord.
Whatever.
Whatever, Lordship, records, whatever the record. Submitted a statement to the undersigned which is enclosed herewith as annexure H per favor of ready reference. It is stated that Sri Diganta Rava abandoned the execution of work and he received the full amount of the work executed by signing the incomplete final bill. Lordship. Sri Kolita further stated that after signing the incomplete final bill, no contractor can resume the execution of work again and also cannot claim for resumption of work. It is therefore crystal clear that Diganta Rava herein, the instant petitioner, was completely aware of the fact that due to non-completion of works, authority has taken appropriate action against him and the workers.
My statement at page 154, Lordship, can you see 154? 154 that.
154. 154.
Lordship. This is my statement, duty and inquiry officer.
Yes.
Lordship, as per work order, number Iman, dated Iman, amount of rupees Iman, involving an amount of rupees Iman and time allotted for the above system was 3 years. As per work order, I started the work after 8 months of the work order. In the year 2021, I have completed my allotted scheme. Abuban work was completed by me only.
Okay, you file an affidavit stating that the payment made to the respondent number 6 for a part of the work was done by the respondents number 6 and 7 and not by the petition. You say that. You have got to say that.
It is filed by the PTC authority, Lordship.
By whoever,
Lordship,
whoever the concerned authority. Then why are you making the submission?
Sorry.
Yes, Mr. Bora. Okay, Mr. S. Bora, Learned Counsel for the BTC submits that he will file an additional affidavit specifying as to whether the respondents number 6 and 7 had had done the construction work for which they had been paid money by the authorities.
Remaining contract.
You see, they have been given certain amount of money. For that amount of money, is it remaining, not remaining? I don't know. You please specify that. I cannot spoon feed you. You see, they have been given some money. So you say that they have been given this amount of money for doing this work. Full stop. The affidavit, additional affidavit should also specify as to whether the petitioner had done any portion of the work for which the respondents number 6 and 7 had been given money by the authorities. List the matter after 3 weeks.
All right, sir.
Interim order pass shall continue.
Interim order passed today shall continue till the next day.
All right.
31. Obliged. Mayor, please, madam. My lord, maybe we need some time,
For what?
because I think the matter has become
It
infructuous.
is infructuous.
Yes, lord.
It is very much infructuous.
Yes.
There's nothing remaining here. Okay, right, Mr.
K. Vishwakarma, madam.
K. Vishwakarma, learned counsel for the petitioner, and Mr. R.K.D. Chaudhary, learned deputy SDI, submit that the writ petition has become infructuous. Accordingly, the writ petition dismissed as infructuous. Enhancement of license fee, well, the catering policy of 2017, everything is there.
33.
Obliged. You know it very well.
Actually, my lord, there was a clause, by violating that clause, they have enhanced the fee. So the honorable court state that particular notice, saying that you can enhance it, but there is a clause you have to give prior notice. So that there can be a discussion how much can be enhanced and all. So that part was not followed. So
Now 2024,
yes, sir.
Lordship will remember, Lordship had delivered a judgment on the new catering policy.
yeah.
It went up to the revision bench. Revision bench dismissed it, the appeal. They took it to the Supreme Court. Supreme Court affirmed Lordship's order.
I oblige.
Item?
May I please, lordship?
Yes, what is the case?
Worship, the item may be taken up, can be taken up after some time. The conducting council is,
Okay, after some time.
And matter of the, ask for the timing, your lordship. Mr. P. Sharma is appearing.
What to do? We need him out here.
And yet 2 year lordship.
No way.
35.
This since my we need further 4 weeks time to file our affidavit.
They have been seeking time and again time.
No, this
Only
for- this is for the
to
second
file
time.
affidavit. This is nothing but delaying of justice.
Mr. Counsel, this is the third time this case has come to the court. Today is the third time only. Right, Mr. B.K. Singh, Learned Standing Counsel, FCL, content a further 3 weeks time to file affidavit in opposition. This is a matter of 3 weeks.
Oblige, man.
36.
Last occasion of right to be funded.
Yes, has it been paid?
Not paid, lordship, sanction order has been issued, lordship. The
Sanction order made.
sanction order to the.
At least it's improving. Things are getting nearer. The end of the road is near.
And when the money is released, that is up to them.
What to do, madam?
And final date may be fixed when
No,
we
no.
will go to pay.
Sorry.
That was the list prepared on the consolidated list. I have annexed in the petition. That was.
Madam, you're not the problem is you're not the only person in Assam who is going to extract money from them. That's the problem. Everyone, in fact, there are persons who are before you. There are persons before you who have to be given money. You cannot say that I should be allowed to jump the queue.
This honorable court may help the petitioner.
Madam,
That they were
if
facing-
it's like this, supposing a beggar owes you money. and he's got just 10 paisa in front of him, and he has to give you 1,000 rupees, what are you going to do? What are you going to do?
Positive.
I don't know, they're taking steps.
Definite statement may be given that.
They cannot. Let us be very practical.
They will
Right,
stand.
Ms. R.B. Bora, Learned Council for the BTC submit that sanction orders and release of outstanding liabilities is being made by the BTC. He submits that the petitioner will be paid as and when her as and when her turn comes, as and when the petitioner's turn comes. Accordingly, this is matter after 2 weeks.
Item number 40 is same.
Same, 40 also.
40, I am not agreeing, but same.
Same. What does it matter?
That may be fixed, my lord.
No.
In this case, I am looking for instruction of the after 3 weeks.
Item
37. Lord. Let it be after 3 weeks. Lord.
Okay, Mr. N. Upadhyay, Learned Counsel for the respondents, number 1, 3, 4, and 5. He's granted another 4 weeks time to file affidavit in opposition.
Obliged.
Mr. Maharaj.
Highly obliged.
10:38. When item 38, I have instructions to withdraw this invitation.
Mr.
N. Gautam, my lord.
N. Gautam, Learned Counsel for the petitioner, submits that he has been given instructions to withdraw the writ petition. Mr. B. Gogoi appears for the Health Department. The writ petition is accordingly, on the prayer of the petitioner's counsel, the writ petition is accordingly dismissed as withdrawn.
Obliged. 39.
Notice of motion was issued on 18/9/2024, and they were asked to, my lord, clear the stand by way of affidavit, my lord.
Lordship, the reason for this not entering the appeal of the petitioner is lordship, as per rule 70.
Not deposited 25%.
25%
That is my only one of the count, my lord. Other counts are they have to answer, my lord, because your lordship kindly see that question, my lord, last occasion they have raised, my lord. That's why could your lordship kindly see the order, my lord, last order, my lord. Because they have to answer, my lord. I mean, because that is pending of the appeal is one of the count, my lord. But your lordship kindly see during the COVID, my lord, entire period, my 3 crore 80 lakhs rupees is there, my lord, in deposit in there still without taking anything, my lord. So that they have to answer, my lord. There are 37, my lord. I have clearly stated, my lord. So that's why I'm going to let them find an affidavit. Yes, let them say that yes, appeal is not been heard, but what is about that, my lord?
No, but then if your appeal is there, let the appeal be decided.
No,
We cannot have
appeal is only one of
we
the-
cannot have 2 parallel proceedings.
No, that may not let them, your lordship kindly see. That's why your lordship kindly, last order, your lordship kindly see what they say, what is the stand, my lord, they order passed by this honorable court, my lord. Because your lordship kindly see, I have paid, my lord, for 5 keys money, my lord, without extracting anything. They have not, my lord, I am now totally bankrupt, my lord. I have no money, my lord. Now, my lord, only once installment they have demanded, and this, my lord, the notice has been issued to my lord, cancel my lord, release, my lord. So let them respond, my lord. I will reply to that. Let them file a affidavit. There are 36, my lord, I'm clearly stated, my lord. 3 crore 80 lakhs, my lord, deposit in their hand, my lord.
How much is the default amount?
Default amount, my lord, now, my lord, only 1 piece money, my lord. That is, they have also not, my lord, clearly mentioned, my lord.
But this is the
32 lakhs, your lordship, at page 160.
this is the requirement of the rules. It is a statutory rule.
My lord.
Then how can
No,
we violate the
for the
rule?
timing, my lord, I am not going to the appeal, my lord. But
No,
other,
but then we cannot behave like an ostrich.
my lord,
The
my
court
money.
cannot do it.
No, then some, my lord, humanitarian consideration has to be there, my lord. Your lordship kindly.
We
there
can
are
only
37. No, if they are not filing affidavit, my lord, I have no objection, my lord. Then your lordship here fix that, I will argue, my lord.
we can have a hearing on the maintainability due to the.
No,
due
at
to
that
the-
moment, my lord, I'm not going to press it, my lord, but my 3 crore 80 lakhs deposit in their hand, my lord. So they have not taken decision on that, my lord. Simply one day before come, they will pass the order, my lord. Where I will go, my lord.
Let this appeal be decided.
My lord, your
Let
lordship
it be
can-
rejected. Let it be rejected or allowed or whatever. And then we can take up all the issues.
No, my
there.
lord, why I am not them? Because
Because this
without
is- this is-
answering these things, my lord, they are not even, my lord, they are, I am repeatedly giving.
No, but then after that it can be done. It
No,
can,
my
it,
lord, by this
everything
time,
can
my
be
lord,
decided.
your lordship kindly, they are avoiding, my lord. If they are, you're like, your lordship, fix it, that's
Mr.
why hearing.
Counsel, it is you who has filed the appeal.
My lord.
It is not your case that you have not filed the appeal. The
Yes,
problem
I
is you
have
have filed
filed
the
the
appeal.
appeal, statutory appeal is there, that's why I'm filing. But there is, before that, my lord, there is another grounds, my lord, to challenge the order, my lord. To challenge the order, my lord, there is another ground, my lord.
Maybe.
When, my lord, statutory provision that they have, let them, my lord, say that, yes, only that because, my lord, I want a affidavit, I reply on pair 37, my lord. Because when your lordship kindly say, I am not default during COVID, my lord, they are not allowed to allow me to, my lord, extract the mineral, my lord. But that money is still there, my lord. But, my lord, now only because one kiss money is, my lord, I am not giving 24, my lord, 24th kiss money, they have cancelled my bill. That's why I want the answer on that, my lord.
And entire thing you have mentioned in para 38.
My lord. No, let them, yes, tomorrow let them say the desired amount we have to calculate.
No, it is you who are saying it. You have said everything in your affidavit.
My lord.
In page 38, para 38, you have said.
No,
that
that is, my lord, my writ petition, that is one of the ground, my lord. It is not only ground to challenge this, my lord. I am challenging the order of, my lord, my lord, cancellation order. Not only on that ground, my lord, that pending is, appeal is pending, but it is, I mentioned it that appeal is pending, but there are another ground also, my lord. That's why, my lord, I want.
What is the other ground? Tell me the other ground.
Another ground, my lord, they have not, my lord, your lordship kindly para 36, my lord. 37, my lord. May I read it, para 37, my lord?
Yes.
That it is the petitioner to mention here that the issuance of the aforesaid termination order dated 13/3/2024 him demanded only 24th kiss money instead of considering already lying deposited and advance deposit kiss money is into 10, 14 kiss and 21 to 23 in the lay head of account in the Department of Forest Department, Government of Assam, paid by the petitioner without extraction of a single stone from the said period of the money, which had earlier resulted due to the COVID-19 pandemic. Subsequently, system of generation technical issue, mechanical issue, and so. The Forest Department lastly, due to lack of environmental clearance by the Ministry of Environment, Forest Department, so to be produced only through the respond number 6, which was delayed due to conduct of the official respond number 6, who have now shifted the burden illegally and unnecessarily upon the petitioner, which is not at all attributed in the eyes of law. So required them, they can deduct from there, my lord, that amount. Because I am totally bankrupt, my lord. I cannot do anything, my lord, now. Because regularly I am paying, they are not allowing me to extract, my lord. But these are still lying there, my lord. On during that, not a single stone I have collected, my lord. But I am regularly paying.
You file a small affidavit, we'll finish it up.
Very well, lord.
Mr. R.R. Goy, appearing for the Forest Department, is granted how much time?
3 weeks time, Lord.
Huh?
3 weeks.
3 weeks time to file affidavit in position, this is the matter of the case. You file, will dispose of the entire thing.
Obliged, Lord.
Please, your lordship, my lordship, will kindly see the Lazima Court's order dated 21/8, my lord. Service on the newly implemented respond number 5 is complete, my lord. Matter is already admitted. Let it come up for hearing. I have a copy of the order.
You have a copy of what order?
Lazima Court's order, my lord, 21/8/2024.
Right. Mr.
And Decca.
M. Deca. Your name is not here.
N Decca is there.
Huh? N. Deca. Okay, Mr. N. Deca. Still for the petition. No, out here there's no N. Deca. So
It is MS and wrongly written as MS and Decca.
Okay, Mr. N. Deca appears for the petition and submits that in terms of the Lavazima Court order dated 21/8/2024, service in respect of the respondent number 5 has been completed. Yes, sir. So records have come?
Records are there, my lord. Matter was admitted on 10/9/2019 itself.
As the records have arrived and the appeal has been admitted on 10/9/2019, list the matter for hearing in usual. No one appears for the respondent. Huh? Mr. G. Bokalial appears on behalf of
1, 2, and 3.
1, 2,
And 3.
and 3. Who is for 4? No one appears for respondent number
Private
4 and 5. What about 4? Is there any
No representation.
any service report with respect with regard to 4?
Earlier, my lord, we have to check, my lord.
Huh?
I have to check the records.
Who is 4?
4 is the private respondent, my lord.
They have filed affidavit in this one. That's one now 4, my lord.
No one appears for the response number 4 and 5.
What is that?
No, this is by me regarding service.
This is the matter after 2 weeks for hearing.
Ma'am. 42.
Acha, out here the issue is that unregistered.
Yes, trade union.
That's right. The issue here is as to whether an unregistered trade union can espouse the cause of a workman. This is the matter after 2 weeks. The hearing. Which is 42.
As per implement, we taken a step, my friend is appearing for.
Yes, yes.
Well, I am appearing for newly implemented respondent number 9, my lord.
9.
Yes, and lordship will find there in the amended cost title, respondent 9 and 10 are the one and the same person.
Okay.
So R10 may be deleted, my lord. My learned friend may be deleted. Because I appear for
Application is required.
my lord. Yes,
Application is required.
he will have to.
Okay, right. Mr. R. Bor Pujari submits that he will be appearing for respondent number 9.
That we have already filed our power.
He further submits that respondent number 9 and 10 really are one and the same person.
Same person.
And as such, an application for
Well, let it be struck out, my lord. For
it is not so easy. I would love to do it, but that is not allowed anymore. What have I said? For striking out the respondent number 10 would have to be made. Pustak. Miss J. Bora appears for
Respondent number 8 you want.
8.
File our policy.
8. Who appears for the others?
R11 has also, my lord.
11 also, no, 11, who's appearing for 11?
My colleague B. Gogoi will be appearing.
Mr. B. Gogoi
11 is. Yes, yes.
appears for respondent number 11.
11. Because G.B. Tripathi, who is my lord currently holding the post of principal secretary, he has been newly implemented as R9, but the same person is again implemented as commissioner and secretary. That is
Okay, so are you filing any affidavit?
Yes, my lord, we will be filing a
The above respondents should file their affidavits within.
My lord, lordship will kindly grant us 4 week time, my lord.
Why 4
Oh,
2018 matter, madam.
in the
Mr.
meantime, my lord, appeal was filed. That is why this delay has occurred.
Okay, it's granted 4 weeks time to file affidavit.
Madam.
Release the matter after 4 weeks. Actually, before that, you write. As per office note, there is no return of AD card or unserved notice from respondents number 10, 12 to 14. This is the matter after 4 weeks.
And so obliged, my.
10 my trade is April.
No, 9, my lord. I have already then submitted my.
Acha, no one appears for respondent number 12 to 14, not 10. 10 cut.
Yes.
Cut. You make an application this
Right.
cycle. Small one.
Right.
1 page.
And so obliged.
For respondent number 1, we have filed an affidavit. Some amount is to be paid. The demand proposal has already been sent to the government. Now
But we know you are going to pay, but the issue is when.
Lordship, sometime maybe even when I'll obtain the instruction after the instruction.
Because affidavit says that you are going to pay.
Yes, yes. Now, the
Only
second
problem is
second-
unless we monitor the situation, you are not paying. That's the problem.
The respondent number 1 and 2, they have already sent the proposal Malab, to the government. First.
Okay, right. Mr. Dean appearing for the respondents number
1 and 2.
1 and 2 submits that. The proposal for payment of the petitioner's dues has been sent for obtaining the required sanction and funds. Accordingly, leave this matter. After 2 weeks.
In this matter, lordship, respondent number 1 has filed their affidavit today, your lordship. May I plead we would like to file a reply to the same lordship. May I plead the matter may come upon 28, your lordship, 28 of November, your lordship. File a reply.
My lord, I am appearing for respondent number 2, my lord.
Lordship, I am for respondent number 1. We have filed the affidavit today morning, Lordship.
Mr.
H.K.
Sharma.
My lord.
Appearing for
Respondent number 2.
respondent number 2 and Mr. S. Mitra appearing for
Respondent number 1.
respondent number 1. Submit that affidavits have been filed.
No,
We have filed the affidavit. They have been.
I am appearing for the first time, my lord, today. But we are yet to file our.
When will you file?
My lord, 3 weeks time may be granted.
HK Mitra, no counsel for the respondent number 2
Yes, ma'am.
is granted 3 weeks time to file affidavit. On the other hand, Mr. S. Mitra appearing for respondent number 1 submit that affidavit has been filed today. Mr.
N. Gautam for the
N. Gautam appearing for the petitioner is granted 3 weeks time. We file
a reply.
2 weeks time to file reply affidavit to the affidavit filed by the respondent number 2.
1 year. 1 year.
Respondent number 1. Accordingly, this is part of 3 weeks.
What you want to pray for a date, your lordship?
Give a date.
Much.
Yes, any settlement?
My lord, your lordship, according to the order passed by your lordships, both the parties sat together. And then, my lord, they said certain papers and what is the precise expenditure, those are to be given. We said you just give a written letter, we shall be providing. After that, my lord, they did not appear. Your lordship, kindly see the letter.
Yes.
The proceeding held on 28/10, your lordship will find in the next page. They appeared and intended to settle the matter. But then after that date, my lord, they did not appear at all.
Yes.
What about my lord? So far, because brief is also with the party, my lord. They took the brief, my lord. After discussion, he felt ill actually. He contacted me, my lord. Supposed to come at this session. And from his telephone conversation, what he said, my lord, that otherwise it has gone smoothly, but they raised some new issues, my lord. After we left the board, that some theft committed of the road or some employees were.
No. This letter, have you got this letter?
No, because
I have furnished it.
You see, this letter
Yes.
basically requires
Yes.
the petitioner to submit
Yes.
the details of the damage, stolen properties along with the cost
Yes.
that you think will satisfy the petitioner.
Yes.
So you submit that. If they agree, they agree. If they don't agree, they don't agree. That's all. What's so difficult?
Yes. Actually, he felt ill. Actually, he could not bring my brief also. He is in church.
Heard Mr. A. Chaudhary, learned counsel for the petition. Also heard Mr. S. Datta, learned senior counsel for the Silchar Municipal Board. Right. Mr. S. Datta submit that pursuant to the order dated 22/10/2024 passed by this court, a meeting was held between the parties and in person to the said meeting, a letter dated, in person to the said meeting. And in the said meeting, it was decided that, here, take this, it decided that from here, okay, next paragraph. The Mrs. Data submits that the petitioner has to make some correspondence with the respondent for attempting a settlement. So on the other hand, Mr. A. Chaudhary, learned counsel for the petition, submits that due to illness, the petitioner could not proceed further with the attempt to compromise the matter. First of, however, as he has now been given a letter, has now been given the letter dated 8/11/2024, issued by the executive officer cum additional DC, Kachar Silchar, the petitioner shall make a written correspondence with the executive officer cum additional DC. The contents of the letter dated 8/11/2024 is reproduced herein below as follows. You take this, okay? Fantastic. In view of the above submission made by Mr. A. Chaudhary, learned counsel for the petitioner, list this matter again on
After 10 days, any day.
not after 10 days,
After 7 days.
after 3 weeks. Because you submit a letter to them, then you have to sit again.
Problem.
Time being 33.
May it please your lordship. Lordship, an office ought to be injurious to no one. Lordship, an office ought to be injurious to no one. And lordship, that is exactly happening in this matter, lordship.
What?
Lordship, there is a legal maxim that an office ought to be injurious to no one.
Okay, so
So, lordship, that is exactly happened in this matter, lordship.
yes, how?
Lordship, the petitioner filed an writ petition before this honorable court that is registered as 7800 of 2022.
Correct.
And lordship, after hearing that writ petition, lordship, an order was passed on 27/1/2023.
Yes.
And lordship, permit the petitioner to apply for an application for renewal of his lease for the Mahal Hatinga Sand and Gravel. And lordship, as per that order, lordship, the petitioner preferred before the respondent number 7 on 6/2/2023. And Lordship, on 6/2/2023, the petitioner visited the office of the respondent number 7, and Lordship asked for the requested the concerned office authorities to provide a copy of renewal application. But Lordship, unfortunately, on that day, that form was not available on the office.
Madam, your senior has asked you to argue this.
Yes, Lordship.
We'll hear you then.
Then Lordship, so Lordship, under company circumstances, and Lordship, as per the suggestion of the concerned office authorities. So Lordship, he submitted a written application for the renewal of his mahal. And which was Lordship, duly accepted by the office with seal and signature.
If it is renewal,
Yes, Lordship.
can there be a renewal of a mahal
Yes, Lordship.
under what provision of law?
Lordship, rule
19.
19. Yes, Lordship.
Renewal or extension?
No, Lordship, renewal.
Renewal.
Yes, Lordship.
Is it a renewal?
Renewal, but he has to submit the application 18 months prior before this expired of this earlier one.
So, okay. So the earlier settlement was for how many years?
Lordship, for 7 years.
From which period to which period?
Lordship, 29/10/2015 to 29/10/2022. 7 years, Lordship.
So that period has expired, so you were settled with the fishery
No,
for
Lordship.
for mining area,
Yes, Lordship.
for mining area.
Lordship.
For 7 years, you were settled.
Yes, Lordship.
Now you want to carry on with the settlement.
No, Lordship, what happened in the time of COVID period, Lordship, as they are not
Able to
able
work.
to work on the mahal or to generate the profit from the mahal, Lordship, so they have preferred before this honorable court the writ petition number 7/2022, 7800/2022 to extend the period.
For what? What was the prayer in the writ petition?
Lordship, that writ petition is not with me, but I can show you the order, which is in page number 144, and the operative part is in 148.
What does it say?
Lordship, in para 7, it's saying that in view of the board consensus arrived at in the bar, the instant writ petition is disposed of by permitting the petitioner to file an application for renewal. Such application, however, is to meet all the requirements under the rules. More specifically, the requirement mentioned in the Rule 19 of the rules. The application as permitted may be submitted within a period of 1 month from today. And authorities, however, shall not reject the application on the ground that the same has not been submitted prior to 18 months of the date of expiry, and the same shall be considered on its own merits. So, Lordship, as per this order, Lordship, he preferred before the respondent number 7 on 6/2/2023. But Lordship, not as per the, he has not
Representation submitted when?
on Lordship 6/2/2023, but Lordship not
6/2/23.
Yes, Lordship. But not according to the provisions mentioned in the Rule 19, Lordship.
There's a specific form, your lordship, MC form 2, which we find at page 382 of the mining concession rule, where they have to submit the application in a specific form. At page 329, your lordship. Form MC2.
Yes.
This is the form which they have to submit, your lordship. And they
Yes.
simply preferred, they simply written down a renewal in an application form, lordship, in a simple representation form, which they had done earlier also.
Okay, so this was not followed.
This was not followed. In fact, as per last of your lordship, it says that at para 5, Mr. So-and-so learned counsel petitioner had submitted that he may be given liberty to submit individual application in accordance with the concession rules, your lord, which would be accompanied by all the requirements at page 147. Para 5. May I read, your lordship?
Yes.
Mr. So-and-so learned counsel of the petitioner has submitted that he may be given liberty to submit individual application in accordance with the concession rule, which would be accompanied by all requirement, including the statutory fee.
Mr. Adhikar, petitioner has further referred to an order to of passing when a petitioner similarly situated like the present petitioner. He himself admitted that he will submit in accordance with the concession rule, Lordship. Thereafter, he merely submitted a representation. So right now, if speaking order was passed, I find there is no wrong in passing speaking order, Lordship, because neither he has paid the statutory fees, neither he has followed the concession.
He has not paid the
Statutory fees, Your Lordship. As per 19.3, the fees have to be paid, Your Lordship. Page 258, Rule 19, Your Lordship. The minor concession rules.
Lordship, we admit that our application.
just a
is
minute,
defective, Lordship.
just a minute. So the minimum fees of 1 lakh was not paid, is it?
Yes. 1 lakh not paid, and further that they have to submit a specific form, Your Lordship, not just merely representation.
But Lordship, they have kept pending that written application from 6/2/2023 to 10/3/2023, Lordship. The office may inform the petitioner because Lordship, the application is defective, but it is curable, Lordship, not intentional.
In fact, the mining period expired on 29/10/2022.
Lordship, that renewal application is confined to law books only, Lordship. If they would have informed the petitioner, then Lordship, he should take the help of a prudent man and follow the all requirements.
Let us see what was the direction passed by this court in page 148.
Yes, Lordship.
Please read. Para 7.
In view of the court consensus arrived at in the bar, the instant writ petition is disposed of by permitting the petitioner to file an application for renewal. Such application, however, is to meet all the requirements under the rules. More specifically, the requirements mentioned in the Rule 19 of the rules. The application as permitted may be submitted within a period of 1 month from today. The authorities, however, shall not reject the application on the ground that same has not been submitted prior to 18 months of the date of expiry, and same shall be considered on its own merits.
So madam, what do you understand by that? That the is to meet all the requirements under the rules, more specifically, the requirements mentioned in Rule 19.
Yes, Lordship, that I understand, Lordship. But on the day when he visited the office of the respondent number 7, that form was missing, Lordship. That
Form was
not-
missing.
Yes, not available on that day. And Lordship, office suggested him to file a written application. And Lordship,
Where have you said that?
yes, Lordship.
Where have you said that?
Lordship, on page 8, para 2. Lordship, under compelling circumstances.
He was not asked to submit in a plain paper. No?
He himself submitted the application to Lordship. as
Lordship,
per
he is
stated.
a layman, Lordship. How he himself submitted an application without the suggestion of the office, Lordship?
Mine, a leaseholder, Lordship, he is well versed with the concession.
When a person deals with lakhs of rupees, he is supposed to know something.
Yes, Lordship. That is all correct.
When he has got the foresight and the intelligence to hire lawyers,
But Lordship, here the office also accepted that written application. If Lordship, that is defective writ application, they should have rejected at that time only, Lordship.
what about non-payment of the fees?
Yes, Lordship, we have not paid, Lordship, but the office would have informed him that your application has this and this defect. So kindly correct all those.
But then
They kept
you are requesting to be spoon-fed all every step of the way.
So, Lordship, in High Court also, Lordship, when we file a writ petition or any, then Lordship, if there is any defect, then that is first sent to the defective session. Then they call us. Then we
High
give
Court
our
is
case,
different.
Lordship.
High Court is for settling disputes.
Yes, Lordship.
It's a different thing. But what about it says that it shall be considered on its own merits?
Lordship,
Page 148.
same shall be considered on its own matter. Speaking on clearly the observation, your lordship, may kindly look page 152, your lordship. Observation 1 says that Hathi Singha said gravel and boulder settled with Sri so-and-so from 29/10 to 15 to 29/10 to 22 under Sonitpur East Division. The validity of the period must expired on 29/10 to 22. Second point, the petitioner, she so-and-so submitted representation data so-and-so to the principal chief conservator of forest and for the prayer, only with a prayer to grant of relief, particularly renewal of lease period Hathi Sand Gravel and Boulder Mahal. The petition not submit his renewed petition in a prescribed form, MC2, along with different details, along with non-refundable fee of minimum rupees 1 lakh as prescribed in Rule 19 of MMC rules. That the findings of lordship will find, hearing was conducted on 10/3/2023 in the office of the principal chief conservator of forest and head of forest for
The
Assam.
problem is this court has directed that your
Yes,
application should meet all the requirements of the rules.
but Lordship, the respond number 7, Lordship, he himself suggested that go before this honorable court. If the court enlarge the time, then we will consider your application. So Lordship,
Madam, we have got to go by the directions passed.
yes, Lordship, that is also correct.
Okay, right. Third, Miss
J. Bezbura.
J. Bezbarwa, learned counsel for the petition. Also heard Mr. R.R. Gogoi, learned standing counsel for the
Forest.
department. And Mr. G. Bokalian, learned junior government advocate for the respondents number 3 to 6, 9 and 10.
My lord.
The next paragraph. Agreed by the rejection of the petitioner's application for renewal of the mining contract. While speaking order dated 14/3/2023. The petitioner has filed the present writ petition. Full stop. The petitioner's case is that the petitioner had been settled with the mining contract for Hatinga sand, gravel and boulder mahal. For the period from the period from 29/10/2015 to 28/10/2022. Pursuant to an NIT. Yes, sir. Due to the loss suffered by the petitioner due to the COVID-19 pandemic, the petitioner submitted an application dated
Lordship, 6/2/2023.
6/2/23. That is after the court order, prior to the court order.
Lordship, on the writ petition is on 18/11.
Prior to the writ petition, did you file any application for renewal?
No, Lordship, maybe.
No.
Only after court order they apply. They prior renewal.
Okay, what have I said? no, file WPC number 78022 in this court. When was it filed? This 780002022. Is it petition? Can we know?
7800.
The petitioner filed the present file WPC 780002022. Praying for a direction to be issued to the authority. Huh? 18 November 20. Wait, huh? Yeah. 18 November 20. No, madam, you had filed one on 8/2/2021. Giving me a
It was
wrong.
a joint application, not an individual.
Whatever.
Yes,
whatever.
they have filed.
Whatever, they are filed.
Yeah.
Whatever I said. No, before that. Due to the loss, cut the bill. Due to the loss suffered by the petition, due to the alleged loss suffered by the petition during the COVID-19 pandemic, where mining work could not be undertaken. The petitioner, along with similarly situated settlement holders, had submitted a joint application dated 8/2/2021. For what? For renewal or what?
Also for renewal lordship.
For renewal. Is it?
Yes.
For renewal of the settlement period. The same not being acted upon, the petitioner filed WPC 7800/2020. Wherein the petitioner's counsel prayed that the petitioner may be given the liberty to submit an individual application in accordance with Rule 19, correct?
Correct.
Rule 19 of the Assam Minor Mineral Concession Rules, 2013. Hereinafter referred to as the 2013 rules. Including the statutory fee paid. Next paragraph. This court thereafter disposed of WPC 7800/2022. While order dated 27/1/2023. By permitting the petitioner to file an application for renewal. This court further held that the application should meet all the requirements of Rule 19 of the 2013 rules, which should be submitted now. Thereafter, the authorities should decide the application on its own merit, and the same should not be rejected on the ground that it had not been submitted within time. That is, it had not been submitted prior to 18 months of the date of expiry of the settlement period. Next paragraph. Consequent to the above order dated twenty-seven one 2023, passed in WPC 780/2023. The petitioner submitted an application for renewal of the settlement period while letter dated 6/2/2023. The same was rejected by the respondent number 7 while speaking order dated 14/3/2023. On the ground that the petitioner had not submitted his application in the prescribed form MC-2 along with the different details required therein, besides not submitting the non-refundable renewal fee of rupees 1 lakh as prescribed in Rule 19 of the 2013. Next para. The petitioner's counsel submits that on the date the petitioner went to the office of the
6/2/2023.
No, to whose office did you go?
Respondent number 7's office.
Went to the office of the respondent number 7. Comma. For being provided with a copy of the renewal application form. The same was not provided to the petitioner due to non-availability of the same. Accordingly, the petitioner had to submit a written application for renewal on 6/2/2023 in a separate letter, by way of a separate letter.
Lordship, that is on page number 151. Sorry, no, 149, Lordship.
Anything else? That's all. So you are challenging the speaking order on what ground?
Lordship, because the form that was, Lordship, curable. The
Stop.
defect.
So stop. The next part, the learned counsel for the petitioner submit
The defect or
that
mistake is intentional.
the respondent number 7 should not have rejected the petitioner's application only on the ground that the same had not been made in the form MC-2, as the said defect was curable. That's all. Next para, Mr. R.R. Gogoi, learned counsel for the forest department. On the other hand, submits that besides the petitioner not having submitted his application for renewal in terms of Rule 19 of the 2013 rule, what have I said? Yeah. Now, in terms of forms C2, form form MC-2, which would be in terms of Rule 19 bracket 1 of the 2013 rule.
Statutory fee has to be paid.
Huh?
Statutory fees accompanying the.
The petitioner has not made a mention of the specific information required in terms of MC-2, which are of approximate, which are 23 in number, which are 23 in number. He further submits that in terms of
Rule 19.
this one, which year? Out here, I've got only rule 19. There's no 19.1, 19.2 in my book.
Page 258.
258.
Yes, Lord.
Oh. 250. 250. In terms of rule 19 bracket 3 of the 2013 rule, every application for renewal of a mining contract has to be accompanied with a non-refundable fee, which is subject to a minimum of rupees 1 lakh. However, the petitioner has not submitted any fee along with the application for renewal, which was a requirement of the law. They accordingly submit that there is no infirmity with the speaking order, which has impugned speaking order, which has rejected the petitioner's application for renewal due to the same not being submitted under form MC-2 and non-submission of the non-refundable fee. Incorrect. I have heard the learned counsel for the party. WPC 7800-2022 has been disposed of by order dated 27/1/2022. On the stand of the on the submission made by the petitioner's counsel that the petitioner may be given the liberty to submit an individual application in accordance with the rules, including payment of the statutory fee. This court has accordingly allowed the same by specifically mentioning that the petitioner's application should meet the requirements mentioned in Rule 19 of the rule, comma, except with regard to the period of limitation prescribed in the rule. Next para. The operative portion of the order dated 27/1/2023, comma, in WPC 7800-22, comma, which is at para 5 to 7, is reproduced herein below as follows. page 148, 149. No, 147, 148. Next. The petitioner has, however, submitted the application in a piece of paper which is not in consonance with Form MC-2, which requires a minimum of 23 particulars to be specified. Which requires a minimum of 23 particular information to be specified. What if I said just read the last sentence? Further, the petitioner has not submitted the minimum fee of rupees 1 lakh as prescribed in Rule 19(3) of the 2013. Though the petitioner's application, assuming that the petitioner's application, no, assuming that the petitioner's government, that the form MC2 was not available at the relevant point of time, the petitioner could have given information in its application form, in his application form, with regard to the specific information to be provided in terms of the form MC2. MC2. However, the petitioner has not provided the said information as required in the form MC. MC2 is at page 252.
MC2 is at page 329.
329. In view of the fact that the speaking order has, in view of the fact that this court had specifically directed that the petitioner's applications should meet all the requirements under Rule 19 of the 2013 rule. And as the same has not been met by the petitioner, this court does not find any infirmity with the speaking order dated 14/3/2023, passed by the respondent number 7. The petition is accordingly dismissed.
I'm so glad.
Organized.
Hearing your lordship, the standing council AFDC informed me your lordship to take up this matter.
That's true. Okay, we'll take it up at 2. How many matters are there?
Hearing matters.
What hearing matter?
But this is a case where my lord, recall, where an ex parte order was passed by the learned industrial tribunal. That order, my lord, will find in page number 29, my lord.
sorry, 25, my lord. So, my lord, there was a dispute been allegedly raised by the petitioner, by the respondent number 6, that she has been terminated from the service. And accordingly, the matter was for arbitration, that negotiation before the Assistant Labor Commissioner. Thereafter, because the parties, both the sides were not present at the time of negotiation, the matter was referred to the labor court for adjudication. That order, my lord, will find at page number 23, that is the adjudication order. The issues were being framed, my lord. So therefore, my lord, the matter reached to labor court, and my lord, and thereafter there was a summons been received from the labor court to appear on a fixed date, that is 30/1/2024. Now, my lord, will turn to page number 24. And on that day, my lord, the petitioner's side appeared without engaging an advocate, and they filed in sort of one statement of brief facts. If I may, my lord, I'll read that. Case number 1 of 2014 in the matter of industrial dispute between Srimati Anita Ravidas and management of Barney Breeze Tea Estate, most respectively submit that the consequent upon directives, the management of Barney Breeze Tea Estate wishes to submit its view appreciating the re-electment of employee Srimati Anita Ravidas, respondent number 6, which follows as hereunder. That Srimati Anita Ravidas did not report to her duties, point number 1, deliberately since June 2009 for reasons best known to her, and several directions were sent to her to join her duties, which she denied intentionally. Point 2, that neither she has been suspended nor stopped her work by the management, that it transpires from her behavior that she is reluctant to her job and has lost her interest towards her work. That several procedures were adopted to motivate and convince her so that she can join in her duties and sake of interest of her family, but all such endeavors went in vain. That the management is not responsible for the stoppage of her work as the industry still suffers human resources. Point number 6, my lord, that by this long absence, she might have lost her work efficiency and inclinations towards job, but applying training and development procedure, she can gain her interest in her job, and management is still sympathetic towards the employee for allowing her to join her duty. So, my lord, what on 31/2014, my lord, what management has submitted before the labor court in a manner that she was not been terminated. She has refused to come to the work. They have intimated her repeatedly to join the work. As because she has not joined the work, her salaries from the were not paid. That was the, in brief summary, my lord, what the management has stated. Thereafter, my lord, the award was passed. After sending this letter, the management did not receive any communication, because on the day when this letter was submitted by the management, the learned presiding officer of the Industrial Tribunal, Kachar, was absent. At least that is what transpires from the record which has been attached with this petition.
What transpires from the judgment or from the award is that you had failed to appear before the court, before the tribunal. After, and you neither had you submitted any written statement after you initially appeared.
My lord, on that, my lord, if I may, my lord, on that event, my lord will see my letter dated, my subsequent communication which has been attached at page number 30, my lord, where I have explained this position, what had happened. And that has not been challenged by that has not been controverted by the learned tribunal while the second order was passed. My lord, if I may, my lord. Page 30, my lord. Annexure 5A is basically an, so while after receiving of this order, they filed an application under Order 9, Rule 13. So that application gives out the fact that petition filed by the OP petitioner under Order 9, Rule 13, deed with 151 of CPC for vacating an ex parte judgment and order
dated 28/8/2015. That in the aforesaid reference case number 1/2014 was heard ex parte in absence of the management side. The management side was all along absent without appearing before the court. The award was also passed ex parte on such and such. They were describing the facts that the management side received notice from the court on 26/1/2014, and the date was fixed for 31/2014 for appearance and WS. Accordingly, the management side filed one petition on 31/2014, which I read, my lord, praying for time and filing of written objection. That on 31/2014, there was no presiding officer in this tribunal. However, the Honorable District and Session Judge S.K. Sharma was in charge of the tribunal. As such, the next date for filing WS was not given to the OP petitioner, and management petitioner was told that there was no presiding officer at that stage. The next date for filing WS will be informed later on, as and when the presiding officer would join in the tribunal court. Further, the said petition dated 31/2014 was submitted without engaging any lawyer by a simple petition was on a garden pad. That being no lawyer engaged by the management side for pursuing the order of the Honorable Court. Subsequently, on after 31/2014, the management side also did not appear before the court on the assumption that they would get notice from the court after joining of the presiding officer. But the management side did not know the absence of the presiding officer. Some other judge would remain in charge of the court. That the actually in absence of the presiding officer and in charge of the district session judge S.K. Sharma proceeded with the case and fixed next date on 26/2014 for filing, probably it will be 15, my lord, for filing WS by the management side. Further, while management side appeared and filed petition, probably no further notice is being required to serve upon the management side. As a result, subsequently Honorable Judge C. D. Debnath was posted as an presiding officer in the tribunal. Thereafter, the present Honorable Tribunal Judge Sri A. N. Ghosh has been posted as a presiding officer in the tribunal court. That accordingly, the present reference case was proceeded against the management side all along in absence of the management. Thereafter, the present Honorable Tribunal Judge heard this reference case ex parte and awarded an award that the management on and passed an award probably languages. Thereafter, the copy of the award was forwarded to the Secretary of Government of Assam, the Labor and Employment Department, Distur, Guwahati for necessary publication in the Gazette. Then, after notification, and the copy of the award was sent to Assistant Labor Commissioner, such and such date. And after receipt of the communication, my lord, from the Assistant Labor Commissioner, they filed this petition. And that has been reproduced here under. This fact, my lord, has not been controverted by the order of dismissal of the miscase number 1. My lord will now.
What fact? What fact?
My lord, now, while passing, there are two issues here, my lord. First is the labor court justified in passing the order of 2015 order, my lord, where it was been asserted by the labor court that she has been terminated. This is issue number 1 in this case, my lord, which I humbly submit, my lord.
Well, when you're not paying you're not paying the salary, you're not allowing her to wait, it amounts to not.
No, my lord, in all my humble submission, my lord, it may not be.
You have not paid any amount.
My lord, it's not like that. Till June, she was serving. Till June, all salaries have been paid. After June, without showing any cause, she did not turn up for the EA.
Where is she now? Is she working now?
My lord?
Is she working now?
In my EA, in the garden, my lord.
Yes.
She may be, my lord, but in some other capacity maybe, but I'm not aware of this, my lord. What I am, my lord, is submitting is this, my lord. With regard to 2015 order, my lord, there has to be a category finding by the court that there was a termination. Without the termination order being in picture, my lord, how come that court come to that finding? In this regard, my lord, if my lord permits, I'll show some judgment of Honorable Supreme Court, my lord, how the court has looked into in case of an ex parte order, where there is no evidence has been placed on record. The burden on the court, my lord, that the evidence has to be analyzed is not taken away, my lord, even though that the respondents were not there. My lord, I please, my lord.
You have not submitted any written statement, nothing.
My lord,
Why should
my lord,
we,
in absence, my lord,
why should we consider this?
my lord, 31
arguments here?
should have been, my lord, considered as my written statement.
Huh?
31 2014 letter ought to have been considered as my written statement.
Which letter?
My lord, that is
13/1/2000?
14, my lord, that is page number 24, which was before the honorable tribunal on that time.
Page 24.
Yes, my lord, this letter was there on record. But this letter was not considered by the honorable tribunal at that point of time, my lord.
Is it there in the records?
My lord, record was called for by the order dated.
Is the record there?
2020, my lord.
Is the record? Is the record? But what is your case?
My lord, my case is this, my lord.
There you did not, you see,
My lord.
You did not appear before the thing. You took time for WS. You did not submit.
My lord, because I was
No.
not aware. My lord, on that,
You are-
my lord will
that-
peruse the judgment, my lord. Because my letter dated 31 2014, the facts which I have asserted by the letter dated 31 2014 was there on record, and it was not been considered in the order. I'll take you through if the honor, my lord permits me. And this fact has been also been asserted in my second letter also, my lord, in my petition.
Yes,
That I have
Mr.
submitted
Gogoi,
this-
what have you got to say?
This page 24, it cannot be treated as a WS lawsuit.
24.
It's a quasi-judicial proceeding lawsuit, tribunal lawsuit. With this kind of letter, how can
Correct.
it
How can it be treated as
lawsuit?
Is just a letter?
My lord, if my lord takes this
They
view,
also
my lord, my lord,
manager. Is the manager competent to submit a letter on behalf of the company?
This letter
That
cannot be treated
competencies
as a WS lawsuit.
Huh?
This letter cannot be treated as a WS lawsuit. Even lawsuit, the technical findings of the Honorable Court, page 28 lawsuit, they have failed to appear before the tribunal lawsuit. In specific. Paragraph 2 lawsuit, page 28 lawsuit. No affidavit, no WS is filed lawsuit, no evidence is reduced, no was appeared lawsuit.
24 can never be
After
said to be a WS.
After receipt of the notice, that cannot be treated as WS. Otherwise,
There's no verification, there's no affidavit, nothing.
otherwise, lawsuit, the very purpose of the act.
It is a
will be frustrated
letter.
lawsuit.
my lord, if the purpose of the act, my lord, if I may, my lord, if my learned opinion is.
No
I
evidence
accept
was
this court, my
taken.
lord, to this, these facts were brought to the record of the court, my lord, to the notice of the court.
You have not
The
appeared.
question is this, my lord,
You have
can
not
this
even
court-
given evidence.
My lord,
You have not even given
I did
evidence.
not knew, my lord, that is the whole, my submission is.
I think you go to Supreme Court.
My lord will, on that case, will pursue this.
WS
My lord,
lawsuit, you have to file WS along with the verification lawsuit.
Correct, no verification, nothing.
Nothing is there lawsuit. It's a
Whether the
simple
manager can,
lawsuit.
whether the manager can even file that thing.
Lawsuit. Then it's a letter lawsuit issued to the lawsuit that presiding authority. This cannot be treated as lawsuit.
my lord, is this, my lord, on that event, my lord will peruse this judgment which I'm relying upon, my lord, of SCC 1988, 3 SCC 366, my lord. Few lines in para number, my lord, 17 at the last page, my lord will peruse, my lord.
Yes,
My lord will see that there is a word, the evidence.
yes.
Let me read, my lord. Even in absence of a defense, the court cannot pass an ex parte degree without relying the relevant evidence. The fact that the evidence, the plaintiff chooses to examine some evidence in a case cannot in itself.
Where are you reading?
My lord, para number 17, it starts from, my lord, on the failure.
Judgment of the High Court.
Yes, my lord. At the last page, my lord,
Yes.
the point of evidence is there, my lord. My lord, is para number 17. Sorry, my lord. Is it my lord? Sorry, my lord. My lord, I'm sorry. Yes, my lord is. My lord, 1 minute. My lord, 1 minute. My lord, I'm sorry, my lord. Wrong reference. My lord has got this, my lord will look into from my copy, my lord, it is. The copy. Format has gone little bigger, my lord. Para number 14, my lord. It is, my lord, 2009 to SCC 2005. The SCC, my lord, may I read, my lord? The evidence adduced on behalf of appellants were not analyzed for arriving upon at the finding as to whether a case for setting aside a decree has been made out or not. Appellant, the matter had not been considered as required in terms of Order 9, Rule 13, the Code of Conduct of the Code of Civil Procedure, my lord. So, what I am submitting here, my lord, is this: the evidence which have been relied upon by the court while passing the ex parte decree, my lord will look into that evidence only for a moment. There is only an affidavit by the workman, my lord, where the workman is said certain that that affidavit, that part has been reflected in the order also, my lord. That side, that is in page number 26, my lord. The peruse the evidence which the court peruses, my lord, at page number 26. The evidence led at the middle, my lord. The evidence is only by the workman, and that too with regard to only by an affidavit, my lord.
So what?
So, my lord, here no termination letter was ever been shown by her.
So what did the tribunal say?
My lord,
What did the tribunal say at the end?
Tribunal does not go. The tribunal only says this because it has not been controverted, my lord.
So you see that the tribunal has not said that she was terminated. Tribunal has said that stoppage of work was there. That's all.
My lord, it has been stated, my lord.
It has been stated that as the management has failed to contest this case and also failed to justify the stoppage of work of the delinquent.
My lord, stoppage of work.
Basically, what the tribunal has said is that though you have not terminated by giving a termination order, you have stopped giving work to the person concerned, to the workman.
My lord, it is an interpretation which tribunal has taken. In my humble submission is this, my lord, that interpretation is not correct because I was not there before the tribunal. She was not coming to the work, and that is the reason, my lord, this order was being passed. That fact we have brought to the notice of the.
That fact you have not brought to the notice of the tribunal. You have not given your written statement. You have not adduced evidence.
The records would have reflected, my lord, that this letter was there.
That letter, even if it is there in the tribunal, does not show that it is a written statement.
My lord, that is what I am saying. My lord,
that is not even your case in your Order 9, Rule 13.
My lord, Order 9, Rule 13, my case is, I'll point it out, my lord. Because I had tried to show a sufficient cause in Order 9, Rule 13 application.
Have you said in your Order 9, Rule 13 that at page 24 is a written statement?
My lord.
Have you said in your Order 9, Rule 13 application that your page 24 is your written statement?
I have said it is in that there is an adjournment request was made. We have not said categorically this is the need. This is my written statement. What I am, my lord is submitting, my lord.
Paragraph 2, Lordship, that
Paragraph 2 of the?
paragraph page 30, Lordship.
Page 30, yes.
Page 30.
Yes. Wait for time for filing written.
How it cannot be Lordship defeated, Lordship. Their case, no, it is their case. No.
You are writing something else, and you are making submissions which are totally in contradiction to your
If my lord comes to this
petition.
also, my lord, whether dismissing my miscase was justifiable, whether I was able to show a sufficient cause or not, my lord, that is in my humble submission is this, that I
I
have
find,
shown
I find that
sufficient
there
cause,
is
my lord.
sufficient cause.
My lord,
I find there is sufficient cause.
my lord, in my humble submission, it is, my lord, the
Maybe,
interpretation
maybe
of
you should
sufficient,
try your luck before the Supreme Court.
my lord, my interpretation of sufficient cause is
Oh, before
flexible,
division
my
bench.
lord. And if, my lord, if I stretch this argument also, my lord, there could have been some cost imposed on the management and an opportunity could have been given, my lord. The injustice here on the management, my lord, is great, my lord.
Will impose cost of 2 lakhs.
That will be, my lord. My lord, that will be. Any reasonable amount, my lord, may impose a cost and my lord they will submit before the
How old was she? How old was the workman?
contract, I think.
2016, her age was 40 years, page 37 also.
2016. So 8 years old. Sure, it should be 51 now.
We have never refused her to take back to work, my lord. That is what we have constantly stated.
Yeah, the problem is you are stating something. You are not even going to the tribunal to file your written statement.
My lord, we were not intimidated, my lord. My lord may impose a cost and give us an opportunity to go back before the tribunal, my lord. Any reasonable amount, my lord, will.
Right. Heard, Mr.
AB Day, my lord.
AB Day.
My lord.
Anything else, Mr. K? Learned counsel for the petition. Also heard Mr. K. Gogoi, learned counsel appearing for the
Client person 1, 2, 3, and 4 also.
respondents number 1, 2, 3, and 4.
5 and 6.
What about 5? No one appears for the respondents number 5 and 6. The management bracket writ petitioner has made a challenge to the award dated 24/8/2015 passed ex parte by the Learned Industrial Tribunal Kachar, Silchar, hereinafter referred to as the tribunal, Learned Tribunal, in reference case number 1 of 2014. The petitioner has also made a challenge to the order dated 22/06/2016, passed in miss case number 1 of 2016, which was an application filed by the petitioner under Order 9 Rule 13 CPC for modification/vacating the ex parte award dated 24/8/2015. Yes, sir. The case of the workman bracket respondent number 6 is to the effect that she is a permanent worker of the Bernie Brias Tea Estate, Hailakandi. And that he was terminated. Was it a case termination or what?
She filed it under termination, my lord.
Huh?
She filed it as a termination only.
And that she was terminated illegally by the respondent without any just cause. But by the petitioner without any just cause. The workman's further case was that she was a member that she was that before termination of her service, the management did not issue any show cause notice, which was mandatory. So conciliation proceeding was
Both sides did not appear. As per the affidavit of the respondent number 4, my lord, both sides did not appear. Then the matter was
in the conciliation proceedings that was to be held, both the sides. Where does it say that?
in
No,
In
cut
page
that.
5.
To cut a long story short, the
Second page. Pranama.
the following issues were framed by the government to be decided by the learned tribunal, which are as follows. Number one, whether the management was justified in effecting work stoppage to the workman since July 2009. Number two, whether the workman was entitled to reinstatement with full back wages, including other fringe benefits. Next paragraph. The learned tribunal passed the impugned award dated 24/8/2015 in reference case number 1 of 2014 by directing reinstatement of the petitioner with full back wages. Okay, what is it? Dispose of, what have I said? Yeah? Last sentence? No, how did it start? How does it? Pass the impugned ex parte order. Ex parte award. No? Date it. Good stuff. Next paragraph. The writ petitioner bracket management thereafter submitted miss case number 1 of 2016 before the learned tribunal under order 9 rule 30 read with section 151 CPC for vacating the ex parte award dated 28/8/2015. Miss case number 1 of 2016 was thereafter dismissed by order dated 22/6/2016. On the ground that order 9 rule 30 CPC was not attractive, keeping in view the fact that a petition dated 30/01/2014 had been filed by the writ petitioner seeking time to file a written statement. Next paragraph. The petitioner thereafter has filed the present writ petition praying for setting aside the award dated 24/8/2015, passed in reference case number 1 of 2014, and the order dated ex parte order, the earlier one, ex parte, and the order dated 22/6/16, passed in this case number 1 of 2016. Next part. The petitioner's counsel submits that the petitioner had submitted a petition, submitted its reply to the stand taken by the workman, white letter dated 30/01/2014, which the learned tribunal should have accepted as the written statement of the petition. He further submits that the management neither terminated the service of the respondent number 6 nor initiated any domestic proceeding against her. So, as the respondent number 6 was absent from service in June 2009, the petitioner had no other alternative but to deny making payment of wages on account of no work, no pay. He also submits that though the management had repeatedly informed the respondent number 6 to attend to her duties, but she neither attended to her duties nor gave the reason for her absence to the management. He submits that due to there being no presiding officer for a certain period of time to man the learned tribunal, the petitioner was expecting a notice to be issued to him, as and when a presiding officer manned the learned tribunal, without realizing that the district judge
Was in charge for.
was in charge of the learned tribunal in the absence of the presiding officer. He accordingly submits that the ex parte award dated so and the order dated so passed it. Reference case number 1 of 2014 and miss case number 01 of 2016 should be set aside.
My lord, record that I have.
And the petition and the matter should be remanded back to the learned tribunal to enable the respondents to enable the petitioner to file his written statement. Yeah, written statement. Yes, what?
Sufficient cause, my lord,
Huh?
that under rule 13, my lord, we had shown sufficient cause. That, my lord,
You see, rule, give me CPC.
Lossi, I have pointed out another thing also, Lossi. The award was published. After publication of the award, Lossi, they have come. As per the statutory prescription prescribed in 17 to Lossi, it says that Lossi, subject to the provisions of Lossi, section 17A, the award published under subsection 1 shall be final and shall not be called in question any court of any manner whatsoever, Lossi. After passing of the award, they have come of the review, Lossi.
You're right.
because
Mr. K. Gogol, the learned counsel for the respondents number 1 to 4 submits that the ex parte award dated 24/8/2015 passed in reference case number 1 of 2014 was give me the industrial dispute act.
that is the award under
Not here. Was published in the
Government Gazette, Lossi.
in the Gazette of Assam, Government of Assam on
It is not the otherwise, Lossi, the order itself reflect, Lossi, award was published, Lossi.
fair.
it was otherwise published on, my lord, 15 February 2016.
15 February 2016.
I was not having any knowledge of that publication.
And
In page 29, Lossi.
the
It is there, reference is there. Lossi.
just page
Page
29.
29, Lossi. Page 29, reference number is there, Lossi. Page 29, Lossi. Reference, Lossi, government notification on GLR, Lossi.
Not and comma, which is reflected, which is referred to. Where?
Lossi, in reference, page 29, Lossi, reference is there, Lossi, government notification
Ah.
of GLR.
Okay, that 15th February 2016. Which one?
15 February 2016, government notification
Ah,
on GLR.
Which has been referred to in the letter dated 21/3/2016 issued by the Assistant Labor Commissioner Silchar. That is, you take this, page 29. This, okay. I made it, a blue. Okay, this reference. Quote. He submits that in terms of section
17 to page 52, Lossi, internal.
17
17 to Lossi.
bracket 2 of the Industrial Disputes Act, 1947, hereinafter referred to as as the Act, comma. Subject to the provisions of section 18A, capital A, comma. An award published under subsection 1 shall be final and shall not be called in question by any court in any manner whatsoever. He further submits that the letter dated 30/01/2014 issued by the manager of the writ petition is not, it cannot be considered to be a written statement. In as much as the petitioner's application under order 13, order 9, rule 13, read with section 151 CPC. In miss case number 1 of 2016 states that on receiving notice from the court on 26/1/2024, 26/1/2014, the management filed one petition on 30/01/2014, praying for time for filing a written statement / objection. He accordingly submits that submits that as it is not denied by the petitioner that notice was received by the petitioner. Comma. Order 9, rule 13, CPC would not be applicable. He accordingly submits. No, he submits that due to non-submission of a written statement and non-appearance before the learned tribunal in reference case number 1 of 2014. The passing of the ex parte award by the learned tribunal did not suffer from any infirmity. Similarly, there was no infirmity in dismissing the application under order 39, order 9, rule 13 CP, read with section 151 CP. In miss case number 01 of 2016. I have heard learned counsel for the past.
Let me just record my one line of submission like that. There are two grounds in the order 9 rule 13. One is service of summons not appearing or been prevented by sufficient cause. And on the payment of costs, that can be that the court can allow people to set aside. I have been prevented by sufficient cause. That is my argument, my lord. That I mean, just one line, my lord, will record it.
Let's just put one more thing. Petitioner's counsel submits that he was prevented from sufficient cause from appearing before the learned tribunal and in terms of order 9 rule 13, the ex parte award can be set aside upon such terms that may be allowed by the court to be just with in relation to payment of cost.
After hearing the parties and making an order, please, madam. By taking-
Naturally, after hearing, what am I doing?
Hello.
No. All this, we're writing down all your submissions is after hearing you. I'm not doing it telepathically or something. Anyway, right, whatever. I have heard the learned classes for the parties. Full stop. The award, the ex parte award dated 24/8/2015, passed by the learned tribunal in reference case number 1 of 2014, has made the following observation. Page 25. Okay. In red, huh? 26 of till 26. Okay. Then page 28. Oh, in red. Then next, the learned tribunals had thereafter passed the operative portion of the award, ex parte award, dated 24/8/2015 as follows. Huh? Take it, it is in blue. Page 28 in blue. Okay. Next. The observations of the learned tribunal made in the ex parte award dated 24/8/2015 clearly shows that the writ petitioner had received notice and had also sought time to file written statement, which he did not do. The writ petitioner also failed to appear before the court, before the learned tribunal on various other dates. Next para. Though the petitioner has tried to make out a case that the letter dated the letter dated 30/01/2014 issued by the manager of the writ petitioner company should have been treated as a written statement by the learned tribunal. The para 2 of the petitioner's Order 9, Rule 13 CPC petition, registered as Miss Case number 01 of 2016 before the learned tribunal, goes to show that the same could not be treated as a written statement, as the said letter was a prayer for seeking time to file a written statement. para two of the petitioner's miss case number 1 of 2016 is reproduced here and below as follows. Page 30. Okay, para 2. Next. Section 17 of the of the Act provides as follows. Hmm, 17. This is only 17, no? It's short. Yes. The petitioners Order 9 Rule 13 CPC petition was made on 19/4/2016, while the ex parte award dated 24/8/2015 was notified in the official gazette earlier, that is on 15/2/2016. Next one. The above being said, Order 9 Rule 13 CPC provides that the court shall make an order for setting aside ex parte decree if he satisfies the court that the summons was not duly served, or that he was prevented by any sufficient cause from appearing when the suit was called on for hearing. Order 9 Rule 13 CPC states as follows. Next para. On considering the fact that next para. On a query raised by this court to the counsel for the writ petitioner as to whether the respondent number 6 is working at present with the writ petitioner, the counsel for the writ petitioner submits that he does not have any instructions with regard to the above query. Next para. On considering the fact that the petitioner had consciously failed to file written statement, even though it had asked for time to file written statement, comma, besides not appearing on dates fixed by the learned tribunal, comma, this court does not find any infirmity in the action of the learned tribunal in passing a ex parte award. With regard to the challenge made to the rejection of the petitioner's application under Order 9, Rule 13 CPC, comma, this court is of the view that the said provision of law is not attracted to the facts of this case. Accordingly, this court does not find any ground to exercise its discretion in this case. The writ petition is accordingly dismissed. This.
Yes, I have given a copy. We already used a new tender process and we have settled it also.
Okay, Mr.
A.D. Chaudhary.
A.D. Chaudhary appearing,
For the petitioner in item number 9, Lordship.
appearing for the petitioner in WPC 3915 of 2021. Submits that the writ petition has become infructuous. In view of the, show me the letter.
Has taken it. I'm giving it, Lordship. I'm giving you the date, Lordship.
I just mentioned in view of the issued by by the managing director AFDC, comma, which is to the effect that the fishery has been settled
One Shri Pranab Das.
with one Shri
Pranab Das.
Pranab Das. With effect from
31st of March 2023
31/3/2023.
to 31st of March 2029.
31/3/2029. That is for 6 years.
7 years.
23 to 29 will be 6 years. Six years.
7 years, Lordship.
Huh? 6 years.
No, Lordship, first year, Lordship,
That is a tender.
23/8/2020. 22.
Huh? Acha, 23/3. No, what is the date? 23/8/22 to 23/8/29. Okay.
No, Lordship, it was 31/3/2029. 31/3.
From 31/3/22. From first.
First, it used to be
From 1/4/2022 to 31/3/2029.
Lordship.
31st of March 2023, Lordship. Beginning then, up to 31st of March 2023.
Just look at give one to him, give one to the other side.
21/10. Wait. Yes. Now here it is written from the financial year 2023 to the financial year 2028 to 29.
Financial year 2022-23. 23-23 to Lordship 28-29.
Then it's okay. No problem.
It is that 21-10-2022. 2022.
Okay,
Issued by the bank.
letter dated 21/10/22. 22. For the period from, for the financial year, for the period from the financial year 2023 to
22-23.
22/23 to 28/29. 28/29, okay. In terms of the tender notice dated, is it there?
Yes, tender notice number 5/2022.
In terms of the tender notice number 5 of
2022.
2022,
Dated 22/6/2022.
dated 22/6/22. How can they give them from that period?
Initially, actually, this was
Must be from 23/24 or something
Lordship,
like that.
initially what had happened, now we have rectified it. Initially what had happened, we used to charge.
Anyway, it's been given anyway. So, first off.
Now we are not giving, we are not,
Okay.
we are not charging.
They have counted Lordship first of April 2022.
Okay, anyway,
Now we are not.
anyway, so what have I said in the beginning? Mr. who?
No, Lordship,
Counsel for the petitioner and Mr. P. Sharma.
yes, sir. Let that submission be come from P. Sharma, because
Okay,
I
okay.
do not
Don't say
have
that. Just say that. Just say that Mr. P. Sharma, the counsel for the AFDC, submits that. Then that instead of AD Sharma. AD Chaudhary, instead of AD Chaudhary. Next, Mr. AD Chaudhary submits that in view of the submission made by Mr. P. Sharma, the writ petition can be closed as instructed. Accordingly, the writ petition is closed as instructed. Okay, that is for item item 9. Now, item 10 is what?
Item 10, Lordship, it was filed initially, Lordship.
So this is also instructed.
That is.
Then you write, Anyway, right. In view of the order dated 11/11/2024 passed in WPC 3915 of 2021, the present writ petition has also become infructuous. It is regarding the same fishery. In as much as the fishery that is the subject matter in issue, the herein is the same as that in WPC 3915 of 2021. Full stop. Next para. The order dated 11/11/2024 in WPC 3915 of 2021 states as follows. When you write that. Next para, you write, in view of the above, this, the present writ petition is also closed as infructuous. Then you write one thing in the beginning. In the beginning of this item 10 order, you write, no one appears for the petitioner. Mr. P. Sharma appears for the AFDC.
Timing 34.
Yeah, Lordship, I brought the record, Lordship.
So remission granted or not?
Remission is around 6 lakhs, but they are supposed to pay us around 31 lakhs. More than that. So what am I learning? I have showed all the records to my learned friend before, and Lordship.
In the last order, your Lordship.
Actually, lastly, in earlier, I have wrongly stated, I think it is around 34 lakhs I have stated.
So you file an affidavit or what? Or what will dispose of?
If you want, then I can file an affidavit.
In the last order, your Lordship, what specific amount?
Yes,
was
specific amount I can say
granted
from the
as
record.
remission is
Okay, how much?
Six
Okay.
lakh something.
Okay, right. Mr. P. Sharma, learned counsel for the AFDC, submits that as per the official records which he has brought today, the specific amount of remission approved and granted by the AFDC is rupees.
Six 675.
6,75, 555. Full stop. However, the amount payable by the petitioner to the AFDC is
But that is your lordship. The 31 lakhs, your lordship, in my petition, I have written, your lordship. The bill was taken possession by the petitioner in the year of 2018. As on date, your lordship, 25 or 26 lakh was required to pay, your lordship.
Can you let us see
My
that?
friend, your lordship, phoned me one statement of the petitioner where he has stated that 31 lakhs is to be paid.
How much?
31 lakh is to be paid here. And apart from that, your lordship, the assessment report I have seen, in earlier occasion, the assessment was made on the basis of the operational area, your lordship. So there is a distinction between operational area and total area, your lordship.
Yes, that is, I got it.
Total area was 40 hectares.
Just a minute. How much?
3128,
31, 28,
651.
651. So
Yes,
you'll have to minus that 6 lakhs from here.
Yes, sir.
So then he'll have to pay around 25 lakhs.
As on 29/1/20.
I
As on 29/1/2024.
I think
Yeah, this is as on 29/1,
2024.
2024. 2024.
I think your lordship, in this regard, your lordship may direct to file affidavit so that I may.
You file a small affidavit.
No,
Mr. P. Sharma shall file an affidavit with regard to the submission made by him today. Within,
Yes, lordship, not on the next week.
within,
Not on the next week, lordship.
within 2 weeks, 3 weeks.
Okay, within 3 weeks.
Huh?
Within 3 weeks will be.
Within 3 weeks. This is the matter of the 3 weeks.
In the meantime, your lordship, one copy may. Oh,
He'll give an affidavit. Everything will be there.
I have shown him everything, lordship.
I have something to say about that, your lordship, because in one order, your lordship passed an order to consider the area in operation. And they have considered it from the whole area, your lordship. The
they
whole
have-
area in operation.
That we'll
There are-
see, we'll see.
They can argue.
Let that will be a different cause of action. Anyway,
And apart from that, your lordship, the COVID there was in 2019 to 20, there was COVID. That one
19
was-
there was no COVID. Sorry,
Oh, sorry,
19 there was
yes,
no
yes, yes.
COVID.
From March 20, your lordship. March 20 to 21, your lordship, there was COVID. And in this period, no business there was, your lordship. So that part, your lordship, need to be.
Yes,
considered.
maybe they'll have to reconsider. I don't know. Let's see. Mr. Sharma, just meet me, huh? 1 minute.